in the court now where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, paying men to visit her at night. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption, strict tight as a vice. In this endless trial, we pay the price.
Hey, all folks, welcome to today. Oh, hi Denise and hi the folks. I am still at work, but I don't want you to miss out on too much here, because there are other streamers, and I know you jump in between us, but there is a decent portion of you who watches just me. So I'm going to play the second half of yesterday in 1.25 speed. I will try from here to be as involved as I possibly can, because it happened a lot yesterday afternoon. So, and as soon as I can, I will drive home, so I can be actually there. Okay, so here we go. The afternoon session of the hearing with the new judge. Let's go.
The next evidentiary motion is Mr. Williams has filed a motion, and again, I don't know whether this is filed for reconsideration or what, but it's an issue we're going to have to deal with going forward. So while I'm not reconsidering prior rulings, we do have to sort out how we're going to handle this moving forward, and that is concerning 801 and self-serving statements. So, Mr. Steele.
There's been a lot of objections. Can't change the past. I've objected to it all. Over objection, I've been prevented from trying the case and putting on evidence based upon this so-called self-serving statement. My understanding, Your Honor, is that changed with the new evidence code, and I cited for the court in my motion that I filed on, Attorney Adams, and I filed on July 10, 2024, some cases, and I might have attached the cases actually to the motion. I can't remember now. Walker, W-A-L-K-E-R versus State, 306 Georgia, at page 44. Can you give
me just
of course.
1 second?
Of course. It's okay. No apology ever, Your Honor. So Walker is W-A-L-K-E-R versus State, and it's 306 Georgia 44, specifically footnote 3, 829 Southeast 2D 121 2019 case, where our highest court wrote that and I'm quoting now, the blanket policy against self-serving statements might not have survived the passage of the Georgia New Evidence Code. Then in Jones versus State, it's 303 Georgia, 496, it's in Division 4, 813 Southeast 2D 360 2018. That case is a pre-January 1, 2013 trial. So the self-serving statement objection was valid. So that's why I put that case in the motion. And then it's a good case of Hodges, which is state actually versus Hodges, Hodges, 291-413, footnote 6, 728 Southeast 2D5, 82, 2012. Obviously, that's before January 1, 2013. But what happened was our Supreme Court said that the new evidence code has indoctrinated or codified, I guess, OCGA section 24-8-801C, and that the new evidence code would not retain the self-serving statement rule. And instead, the court looks at relevance 401, 402, and then obviously 403 is for everything. In federal courts, United States versus Jackson, JCKSON, 780F2D, 1305, it's 7th Circuit, 1986. For over 40 years, self-serving rule was not followed in federal courts. And here, what was happening is anything said by Mr. Williams that I tried to get in on cross-examination would be met with an objection that was sustained as self-serving statements. At times, the recused Judge Glanville would allow it in under the rule of completeness. So 106 and 822, or 24-1-106 and 24-1-822. There were times that he let in, but self-serving statements were excluded, even though they weren't going to innocence, which under the old rule, self-serving statement has to go to innocence. That's why it's self-serving. But anyway, I'm not saying that it's ever going to come up, but it happens so frequently. I just wanted to be courteous because that's the way it was going for several months in the court. So I just wanted to raise that to your attention. That's really what it is. In paragraph 11 of that motion, Your Honor, there was not as much, but under, I think it's 24-8-801. You got, and I'm looking, it could be 2B. I'm not sure that's right, but I think it's 2B. It deals with a statement that's adopted. So Judge Glanville would allow in, well, this was sent on social media and your client didn't respond. Oh no, that's not accurate. Or there was an alleged meeting and your client was there and he didn't deny it. Or somebody else had a lyric in a musical song and your client didn't come back with the next verse and say, oh no, that doesn't apply. And that's not an adoption has to be specifically intended to adopt by your silence. Like, so anyway, those are my issues.
Okay.
They came up a lot. I'm not, Your Honor, I'm not saying that there'll be issues going forward, but it like permeated this trial.
Okay. I appreciate you bringing all of that to my attention. And I mean, this isn't really, I guess this is more bringing it to my attention than anything else. We're not talking about anything specifically right now. And obviously, as we're moving forward, we'll take up specifics of things as I'm going to say as we get to them, although if there's evidence that either side knows they're going to be intending to use that might have issues or objections, let's try to deal with that to the extent we can before we're in front of the jury. I think I said that already. But, I looked at all your case law and I've looked at the statute and I don't know whether maybe some people were just using self-serving as sort of shorthand for something. I don't know, but I agree that there is not that's really no longer the issue. And if something is going to be excluded, it's not going to be on the basis that it's self-serving. It's going to be on the basis that it's hearsay and there's no recognized codified exception that has been met. So, I mean, that'll be my intention going forward is, to look and see is it hearsay? And then if it is, and obviously a prior statement of your client is probably going to be hearsay unless and until he testifies. So the question is going to be, does it come in under an exception? Is it a prior consistent or a prior inconsistent statement? And with regard to adoptive admissions as well, I agree. There has to be something to indicate, not just I heard it and I didn't say no. It has to be I heard it and I didn't in some way dispute it when the circumstances would expect me to dispute it. So yeah, generally speaking, that's my understanding. And like I say, we'll take up the specifics as they come at us.
Thank you, Your Honor.
All right.
That was the totality of that.
Great. Thank you.
Can I ask a question?
Yes.
There's I don't want to take something, but there's a transcript of the January 10th, 2024. That's yours?
Yes.
Okay, I just want to make sure.
I don't know. I think I handed yours back to you before.
Okay.
So I handed, or through my staff attorney, handed you back your copy. I don't know what that is. Okay, understood. All right. The state has a motion to exclude victim character evidence. It was filed on July 23rd, and I don't know if that's something that has been ruled on previously or what this one is really. Has that already been dealt with, or where are we on that?
It has come up, Your Honor, ADA action on behalf of the state. The state wanted to file that for the court's guidance of any motions where we were going through specifically Mr. Copeland's redactions.
Okay.
And there was a couple times, and Judge Glanville overruled the state's objection. We wanted some, what we classified as speculative homicides that the deceased victim, Mr. Thomas, was involved in, that Mr. Copeland speaks about in his interviews.
Okay.
And so those redaction conversations with the court were after June 12th. So the state, foreseeing and forecasting at least that specific issue and or additional questions that may come up, wanted to file this motion precluding improper victim character
Okay.
evidence, Your Honor.
And flesh it out a little bit more for me.
Yes, Your Honor.
So Mr. Copeland wanted to testify to, and or you all had prior statements where he had mentioned and you wanted to get in him saying something about homicides that Mr. Thomas had been involved in perpetrating
So, Your Honor,
potentially.
yes, Your Honor. And I have let me draft these notes right now.
Okay.
I wanted to show these examples that I mentioned. So, Your Honor, I printed some examples where Mr.
Okay.
Copeland, this was what the state wanted to keep out. So,
Wanted to keep out.
yes, Your Honor.
Okay.
And the way that the Honorable Chief Judge Glanville addressed these redactions was, state, let me know what you're not playing. And
Right.
then defense counsel would bring up questions they were going to ask Mr.
Okay.
Copeland and or play. So there was portions the state was not going to play and defense counsel said they wanted to get into where
Okay.
Mr. Copeland is mentioning there's a murder on Auburn Avenue. There's an individual by the name of Scooter. And it comes up kind of off the cuff of he heard that Nutt had something to do with this murder. And so the state felt that that falls under what's kind of classically a specific bad act of a victim, which can't come in under really any witness to include a deceased victim in a case. And the case law and the state's motion on that is, explains all of that, I feel like, succinctly. And so the state, knowing that we're going to have to go back over these interviews with Mr. Copeland,
Okay.
and some of this may depend on the questions asked and his responses, the state filed this motion. There may be other instances. Those are what came to mind because we recently addressed those. And they're in a recorded statement of Mr. Copeland that the state did not want to play, but defense counsel wanted to ask Mr. Copeland about and or play it if it was impeachment.
Under what basis, if y'all had gotten that far, and maybe it's more fair to ask the defense.
I was
under
gonna
what
say that, Your
basis,
Honor.
But,
I will defer to the defense on their basis for that because I don't want to misspeak
Okay.
for them.
all right. Somebody from the defense want to let me know what they might intend to argue with regard to this type of evidence?
Couple things. First of all, regarding Mr. Thomas's character in general, the state, and I defer to the recordings. I don't have it in front of me. I'm not intentionally misspeaking. My recollection is Miss Love indicated on January 10, 2015, Mr. Thomas was just hanging out, on the street with his good friends, having a good time and, just having a friendly time. And then these mean guys did this thing to him, which was misleading. But then the state presented witnesses that said that Mr. Thomas was a gang member. This wasn't us. We didn't bring this up. That he is a gang member, that he was a gang leader. And then they brought in experts that talked about If Gang, Inglewood Family Gang, and Bird Gang. And these are the gangs that Mr. Thomas was associated with. And so all this character evidence has really come from the state's witnesses and it's been elicited by the state. Now, regarding what Mr. Atkins just spoke of, I think we're putting the cart a little bit before the horse because these are things that Mr. Copeland said in out-of-court statements. I am not conceding. I hope Your Honor is considering the prior argument today about whether the statements regarding what Mr. Garlington said, or Mr. Garlington's statements, alleged statements to Mr. Copeland, are even admissible. But then there's another issue. Even if they were admissible, our stance is that Mr. Copeland on the stand, and assuming he testifies consistent again, would not deny making those statements. So I don't even know why we're playing prior statements to begin with. All that being said, my recollection of the arguments were that Mr. Copeland was making references to what he knew
Mhm.
about Mr. Thomas as, you know, a gang leader that may have been involved in other violent acts. My recollection of the litigation of that issue was that certain defendants, and it wasn't on behalf of Mr. Stilwell, but certain defendants have argued that Mr. Copeland is responsible for the death of Mr. Thomas. And the argument, as I recall it, was that if that's the defense's theory, that Mr. Copeland's belief and understanding, you got to remember in context, Mr. Copeland, aside from all the gentlemen here, was embroiled in his side controversy with Mr. Thomas's brother, Mr. Watts, Kelvin Watts. And there was a fight a couple days beforehand at Club Crucial where Mr. Copeland's face was blooded and he was robbed, essentially.
Right.
So he had this side disagreement going on with these individuals. And my recollection of the argument was that Mr. Copeland's knowledge and belief that Mr. Thomas had a history of violence created the motive to essentially a preemptive strike. That he knew that he was in a beef, in a disagreement with dangerous people, and that goes to his motive.
Okay, he's
Mr.
not,
Copeland.
yeah, who is not alleged to have had, by anybody, as far as I can tell from what y'all have said to me today, to have had involvement in Mr. Thomas's murder before the fact.
I don't know. That's not been the state's theory, and that has not been Mr. Stilwell's theory.
Okay.
But that did come up.
Okay, well, it may be that what Mr. Copeland thinks about Mr. Thomas's violent reputation is entirely irrelevant then.
It may be irrelevant. I don't want to speak for other counsel, but that's my recollection
All right.
of the events. But again, I think that, in my personal opinion, the most prudent thing is to figure out which of these statements are
Right.
even going to be admissible
Sure.
first.
Yeah.
But in general, Your Honor, the defense is not. We haven't been bringing out evidence about Mr. Thomas. The state played a video where Mr. Thomas's brother was carrying an assault weapon in a barbershop at the time of the shooting. The state's witness said that Mr. Thomas had a gun and was shooting back at whomever shot at him on January 10, 2015. That's all come from the state's witnesses and has been elicited through direct examination. It hasn't come from us.
Okay.
Your Honor,
Yes,
I wanted to briefly, if the court would permit, I found my notes just to
Okay.
give the court some examples.
sure.
So these are from my notes, so the time hack should be pretty close. But for example, in the January 28, 2015 interview of Mr. Copeland at Atlanta Police Department headquarters, right around 7:48:13, which is the time that evidence reviewer uses, Detective Dennis asked, "What do you know about not having anyone else out there?" I might have missed a word, either killed. There was some alluding to that. And Copeland, I have, says, "On Cleveland, don't know much about it. What about the boy on Auburn?" And Copeland says, "Who? Scooter?" And Detective Gaither, another APD gang detective, says, "Mr. Copeland, tell us more." You start smiling. And Copeland says, "I heard something, but was not much. It's just like he did get caught up. Somebody had him killed." So it's that kind of, in the state's opinion, speculative examples of specific conduct. And that's why in the state's brief, that I know the court has reviewed these briefings, a April 2024 Supreme Court of Georgia case, Ward v. State, 318 GA 884. I used in Ward, it's dealing with kind of the outer limits when someone's claiming self-defense. I like reading Ward, one, because it's the highest court in Georgia and it's recent, but number two, not being able to use specific acts of the victim as character evidence, and even a self-defense allegation, which no defendant in this case has alleged that they shot Mr. Thomas in self-defense. It still establishes it must be through reputation and opinion only. And so the state's kind of, it's a two-part motion specifically. Character of the victim is rarely relevant in a murder trial. And two, if it is relevant, it has to be through reputation or opinion on some salient issue. And three, what Mr. Copeland's discussing about, to the state's understanding, is quite speculative even at that. But the state's position is specific bad acts, which murder, I can't think of a more concrete example of a specific bad act of a witness or deceased victim than murder. So speculating about that, the state feels that's just classic improper under 24-4-404 and 24-4-405 alpha.
Okay, well, I plan to follow 24-4-404 and 405. That's about as much as I can say about that right now until we get into specifics either. All right. But thank you for at least fleshing it out so I understand what we're talking about. All right. The state has a motion to compel defendants' compliance with reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And I had, via email, asked specifically as to the authorship of this particular motion and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, "I will be present." Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id.
Yeah, folks. This part of yesterday's hearing is amazing. We really need to pay good attention to how it seems like this judge will handle Miss Love's antics.
Meaning, see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying,
you wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
All right.
I made. And then when I amended it,
I didn't see an amendment.
I have a copy of the book.
Did you fix that?
What I did was
Thank you.
sort of elaborate on it, or yes, I guess you could say it's fixed.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
Okay.
not, yes, I was not saying that. I was saying,
Good to know.
my apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was,
Did you email the amendment to my chambers?
I did
Okay.
yesterday.
Yesterday. Okay.
Yes, it
Well, that
was.
may be why I haven't seen it, although I've been looking at y'all's stuff nonstop. Okay. Wait, it's in front of me now. So
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343, and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite two relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control, my apologies, where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right. So it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
That is, yes.
Okay. So as long as we're all on the same page with that, and I actually do think that to the extent anybody might want to take a closer look at what those distinctions are, I think it's Waddell,
Yes.
where the court actually says, hey, you know what, these can be tricky, these can be dicey. Here's what it means. Here's the difference between the two. So I would recommend for everybody's reading pleasure the court's exposition of that issue in the Waddell case.
And in that amendment, I did correct
All
the
right.
Waddell site.
Okay. All right. So we'll follow that law as well.
So, Your Honor, the
Yeah. And so I guess I don't know if you've got specifics with regard to things that you believe have not been turned over or
I
that
do.
exist and haven't been turned over.
Well,
Okay.
I cite, for example, in these amendment to the supplement on page 1, the first example was recordings that were held by counsel for defendant Williams of an interview conducted with state's witness Adrian Bean. The evidence that was shown at trial was that Mr. Bean was a co-conspirator with defendant Williams in an intrinsic armed robbery. The state conducted days worth of direct examination of Mr. Bean, only to learn the weekend before the day cross-examination of Mr. Bean was to begin that counsel for defendant Williams had a recording of an interview he had conducted along with his investigator, which had been in counsel's possession since January of 2023.
Okay.
In which Bean claimed that defendant Williams was never involved in the armed robbery, and in which Bean claimed that the police told him to put defendant Williams in the crime. Mr. Williams presented this statement not just as impeachment evidence, but as substantive evidence. And further, based upon information provided by being to the state, upon information and belief, the recording that was given to the state was only a portion of the recorded statement at issue. And we do not have, if there are further statements, if there are further recordings, we don't have them. We've not been offered them. We don't know what they consisted of. Another example is Defendant Williams has asserted verbally that he is in possession of a video recorded statement of the witness currently on the stand, in which that witness reportedly asserts, "We killed Nutt," referring to Mr. Donovan Thomas. The state is not in possession of any such recording, is unaware of the existence of one, but as I stated earlier, Mr. Williams has asserted verbally that he has such a statement. Mr. Copeland, as I stated, is currently on the stand, and the state has not been given any such recording or been privy to or been able to review any such recording despite a specific and direct request for it. We assume that Defendant Williams intends to use the recording if one even exists, not simply for impeachment purposes, but as substantive evidence. Given these explicit and deliberate decisions to withhold material specifically that we've outlined above, and I will also point the court's attention to a similar example of with intentionally holding back material. There were jail recordings of the witness on the stand now, Mr. Copeland, that apparently Defendant Williams has had in his possession for quite some time, long before Mr. Copeland took the stand. And we were only around the time that Mr. Copeland took the stand presented with these recordings. We expressed having a problem with being able to access them. And we were given another set of recordings that contained some other files that maybe were missing in the first one. But the deliberate withholding of these items is what has prompted the state to ask the court for relief here. We are not asking the court to exclude late, disclosed discovery. That's not what we're asking for, but deliberate intentions to withhold information that a defendant intends to use both as substantive and impeachment at the same time. Evidence. We're asking for the relief that we have referenced in our initial motion. And if the court is not inclined, as we stated on page 5 of our amendment and supplement to the state's motion to compel, we recognize that both Georgia and federal authority instruct that courts employ the least extreme sanction to remedy discovery violations. If the court deems exclusion of a particular piece of evidence too extreme, the state requests that the court issue an order directing defendants to permit the state to inspect and copy any and all material that a defendant possesses, which the defendant intends to admit as substantive evidence, even if the material is also impeaching of a witness, and directing that where the proffering defendant intentionally withholds such material, that it be admitted, if at all, solely as impeachment evidence, and with a limiting instruction prohibiting the jury from considering it as substantive evidence.
All right. So with regard to the three things that you outlined specifically, you now have the recordings of witness Bean. Is that true?
We have one recording of witness Adrian Bean that apparently was made on an iPhone, but is, according to the information that the state received from the witness as he got off the stand, that may not reflect all of what was taken down.
What do you mean by taken down?
Well, there were, as the witness left the stand, he indicated that, and actually on the stand, he instructed Mr. Steele to keep it 100, implying that that's not everything. In other words, that what we were hearing was not everything. The recording itself was kind of degraded, and we were not, it did not appear to be one pulled directly off an iPhone the way that an iPhone would, the quality of an iPhone recording would be. And I apologize to the court, but there was one more instance. D'Angelo White was a witness that the state put on the stand, who represented to the state that that counsel for defendant Williams recorded the interview, or appeared to be recording the interview that he conducted with D'Angelo White at the Fulton County Jail. We've never received any recording of an interview between counsel for defendant Williams or anybody else conducted at the Fulton County Jail. I believe I heard earlier reference today to, I don't know if I heard that was a subject of any ex parte hearings or meetings with the court between counsel for multiple defendants in the court. But if there were or are any interviews of D'Angelo White in anyone's possession or that were made, we would believe the state to be entitled to them. He was a witness who was examined and cross-examined on the stand. So there were 4 instances.
All right. Well, he already has been examined and cross-examined?
Yes.
Okay. And no such recording was used?
Right. They didn't.
Okay. Then why would y'all be entitled to it?
It's just an example of something that we weren't aware of.
Okay, but y'all aren't entitled to be aware of every aspect of a defendant's case. You are entitled to something that would have been a recording that then gets used as substantive evidence, but it sounds like that did not.
The court is
right?
correct.
Okay, so that one Doesn't
Those are
matter. Okay. So Mr. Williams saying he has a video recorded statement of Mr. Copeland saying we killed Nutt, which he might want to use as substantive evidence, as well as any jail recordings of jail calls of Kenneth Copeland, I guess, with anybody, I would assume.
And we have been,
Y'all got all of those too, right?
so we have been provided, these were not jail call recordings from the Fulton County Jail, they were
Okay.
from a different, but we've been provided according to defendant Williams, counsel for defendant Williams, we've been provided all that they have.
Okay.
And so if that is the case, then there's no further issue.
Okay. That one's fine too.
Correct.
So, Mr. Steele and or any other defense attorney, if you have recordings or statements or anything like that, that you intend to use as substantive evidence, whether it is in a case you might present later or the state's case, I think you know this, but need to disclose that to the state. Now, if it just comes up at the very end that, oh my gosh, I didn't know I was going to use this, but now I think I want to, then we might have to sort out whether that's in fact what's going on or not. But I expect everybody to abide by their discovery obligations. If I end up making a determination that somebody is willfully failing to abide by those obligations, then I will consider sanctions. But I would hope at this point, and with what I've already heard, I haven't really heard anything that I find alarming and improper. So unless anybody wants to say anything else, I'm just at this point going to say I expect y'all to abide by your discovery obligations.
And Your Honor, if I may add one more thing, I believe that counsel for defendant Williams emphatically stated he does intend to use a video recording that he has in his possession of the witness currently on the stand purportedly saying what he asserted, and that we're
Okay, well, I mean, I can see how that might be impeachment evidence, and I'll have to hear whether and how it might be substantive evidence. Mr. Steele.
May I have 1 second, Your Honor?
Sure. This is a long second, Mr. Steele.
No. Hopefully it'll be worth it. Thank you, Your Honor. So I believe that what the state has asked you to do and what you said from the bench about the law that will apply in this case is not accurate under Georgia law.
Okay.
I also, again, I'm not going to continue to repeat. I hope that you would take it the way Judge Glanville did. I have all objections to any proffer made by District Attorney Love. They are not only wrong, but I'm going to show you why they are knowingly wrong. This is the 4th time we're having the same hearing. I know you're not here privy to this.
Okay.
What Prosecutor Love did not tell you is the Georgia law that I've already handed to them. Judge Lambo has ruled on this 3 times.
Okay.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Ms. Love intentionally, I assume, she has a memory of this because she was here. I handed her all these cases. So I assume that she's doing it intentionally. First of all, what she has told you about the case in your reading of Waddell is not accurate. The original case that the state is using is a case from the 4th Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If the Honorable Court would look at United States versus Harry, which should be in your package. I may not have put this in perfect order because one of them were not stapled, but you should have the United States. Okay, and Harry is Harry, and it is 2014 U.S. District Lexis, which is Lexis 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case, and that starts, Your Honor, on page 11 of 17 of the copy of the Honorable Court and the parties. And if you can turn to that page, if you don't mind,
I'm there.
on the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is Y-O-U-N-G, the 4th Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the 4th Circuit was applying the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, HSIA, the 4th Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the 4th Circuit held, encompass both the parties' case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompass all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The 4th Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which the party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there have been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young, but Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, Green. And if you can take a look at the most recent Green case, which you should have in your package.
Yes.
And for the Honorable Court Reporter, this is going to be Green, no E at the end, and it's 368 Georgia Appeal 74, 889 Southeast 2D 190, 2023. And what the Honorable Judge Pipkin, which is Pipkin, states, and Your Honor, you could look at, if you don't mind, at this case on page 3 of 5, a copy of the parties, and the Honorable Court, footnote 3 is at the bottom left. And it reads, we also agree with appellant. This case was reversed. So let me just take a step back, if I may. What happens is the state did exactly in the Green case what Ms. Love's asked you to do here. They said that the lawyer for Mr. Green had evidence for a while, didn't turn it over until the day of trial. The judge excluded it because the quote, and this is a quote, sat on it too long. Therefore, the state was prejudiced and excluded the evidence. And the Court of Appeals said, there was no evidence of bad faith or prejudice analysis, so we're reversing. But they dropped this footnote. And the footnote they wrote, and I'm quoting, we also agree with appellant that it is not at all clear that the defense failure to timely disclose, and I'll just tell you, but TALON_S note was in fact a discovery violation, given that talent was a state's witness, COCGA section 17-16-7, requiring the production of statements concerning the testimony of witness. That, and it's in italicized, so it's stressed, the party in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. The next line goes further, and I'll explain it if you don't mind. It's very easy to explain.
Yeah.
However, we assume, I'm just reading the footnote, for purposes of this opinion, that the note was subject to discovery, and we need not resolve the question or address any possible tension between, and that gives the 2 code sections that we're dealing with, OCGA 17-16-4, little b as in Barry 1, and OCGA section 17-16-7. So if we look now, and I should have given this Honorable Court and the parties a copy of both code sections, OCGA section 17-16-4. If you look at that first, assuming everyone has it, and it starts for the criminally accused obligations under the Discovery Act, and Mr. Williams did, in fact, opt into discovery. And if you look at the copy I've given this honorable court and the parties, it starts on the very bottom of page 2, but it just says B as in Barry, but it really goes over, Your Honor, to page 3. And that's where the 1 is in 1716-4 in the copy I've given. And it says that the defendant, within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties, or as ordered by the court, to inspect and copy photographs, books, papers, documents, photographs, tangible objects, audio and video, tapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, custody, or control of the defendant. And this is what I stress, Your Honor, it's stressed in the footnote, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. Your Honor, under OCGA section 17-16-7, if you look at that, I've given a copy of that to Honorable Court and the parties.
Mm-hmm.
And that has, if you give me 1 second, that has no later than 10 days prior to trial, or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing, other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in possession, custody, or control of the state or prosecution, or in possession, custody, or control of the defendant or defendant's counsel that relates to the subject matter concerning the testimony of the witness, that the party in possession, custody, or control of that statement, and this is what I stress, intends to call at the trial or such post-indictment pretrial evidentiary hearing. I didn't call these witnesses. So the reason that it is so important is we're just dealing with who's case in chief. Georgia doesn't have the pre-2002 Rule 16 analysis that was done in United States versus Young. This is not even close. Page 5 of 7, and Your Honor, I am now in the other green. So it is GREEN versus state, but it's 307 Georgia 171, 835 Southeast 2D 238. It's a 2019 case. No relation that I know of. It's in Division 4. It's on page 507, like I said. Left-hand side, the last line before the footnotes, 2 lines up, actually. It says, however, that is not what Georgia law requires. As provided by the plain language in 1716-4B2, the statute does not require a report to be prepared and made available or served unless the defendant intends to introduce in evidence in defense, in the defense case in chief or rebuttal the results of the scientific test or experiment. If you go to the next case, which should be, or another case, I don't know if they're in order, but it's Carmichael, Your Honor, which is CARMICHAEL versus state, 353 Georgia Appeal 64. That's 836 Southeast 2D 184, 2019 case. And Your Honor, if you can turn to, from the copy of the Honorable Court and the parties, page 7 of 8. And Your Honor, this is on the left-hand side, the first full paragraph, but counting from the bottom, 9 lines up on the right. I'm quoting from our court, and this is just one case. There's so many. Just before the state rested its case in chief, the trial court instructed the jury that when a stipulation is entered into the facts, as to facts of other parties, you can accept those facts as being true without further proof. My point is, their case in chief is, it's a term of art.
It has a distinct meaning.
Yes, and if you go back to the Harry case, it's actually a fascinating case to read. It's an enjoyable case to read. They go through case in chief versus evidence in chief, and they talk about specifically all the U.S. Supreme Court cases. It's on page 8 of 17 of United States versus Harry, Your Honor. It's well written. It's really a good job. On the left-hand side, the first full paragraph on page 8 of 17. And the district court in New Mexico wrote, courts have repeatedly used the term case in chief to refer to the part of the trial between the time that party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue. So I, for the 4th time in doing this, the state then has, or the court said that it wants to know about Waddle. Waddle is different. Waddle specifically, and I assume that you have the case because I heard you refer to it. If not, I can get it.
I do.
So in United States versus Waddle, which is WADDELL, and it is 2016, U.S. District, which is DIC period, Lexus, LEXIS 68748. It was decided and filed on May 25, 2016 by the district court in Southern District of Georgia in the Savannah Division. Your Honor, if you go, and I'm not saying we have the same copy, so this is on, I have page,
Maybe what page of the slip opinion?
I'm trying, I think it's page 11 is what I'm looking at. It starts out with one final point. Okay. So the Waddell case, the judge said, no, you don't have to give it over, but if you're lying, I'm not saying that's
Right. No, I read it. Yep.
Then you're going to be in a lot of trouble or something to that effect. But what happened in the issue in Waddell was they were talking about a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, it would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
That's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp. She told our investigator, she didn't call me, give me any recordings that you have of Mr. Bean, the investigator's skill. So he must have said, I wasn't on the phone. But Ms. Love then reported it to Judge Glanville, who said that was appropriate. He shouldn't have given me anything. Said, Mr. Steele's investigator is obstructing us. This is so wrong of the prosecution. 4 times I've given the same case. 4 times I gave that Green case. 3 times Judge Glanville ruled. In addition to that, there's factual, not only, am I rejecting, I am never taking Ms. Love's proffer. Okay, so she says that I don't talk with Ms. Love, by the way, if you didn't know that. So I never said anything to her. But that I
Is there
said,
somebody on the state's case that you are able to talk to?
yeah, Ms.
Okay.
Willis.
All right. Well, okay.
On
Go ahead.
the second page, and I'm just looking at the amendment to supplement on page 2, in the center of the page.
Right.
And I should start above, but I'll get to that if you don't mind. For another example, Defendant Williams, it's me that she's talking about, has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts we killed Nutt, referring to Donovan Thomas. But let me tell you how that happened. I never said that. Ms. Hilton sends an email and says, upon interviewing Kenneth Copeland, we found out that he put out a social media recording that he killed Nutt, or we killed Nutt. It's in writing. Can you please give it to us? We can't find it. The most I may have said, which I don't have a memory of saying anything, is I'm not giving you anything. If I use something, I'll use it in court. That sounds like something I would say to these prosecutors. To other people, I would say, you're going to have to, I don't have to give it to you. I'm not going to be able to talk about that. I never said, I verbally asserted that I have anything. But if I do, I'm going to say the same thing that I'd always say. I'm not giving it to them. If you tell me to do it, I'll do whatever. But I'm not going to give them anything because I don't have to. That would be impeachment. Mr. Copeland, before the 12th day of June of 2024, specifically was asked by Ms. Hilton, did you kill Nutt? And he said no. That would be impeachment. The next one, that I did not give over Mr. Copeland's jail calls until recently. Let me tell you the truth. October 2023, I gave jail calls of Mr. Copeland to the state. October 2023. The state doesn't raise this until more recently when Mr. Copeland is a witness. They want me to tell them which jail calls am I going to use to impeach the man. I said I'm not going to do it. Judge Glanville said you don't have to do it. I'm not going to do it unless you tell me to, but I don't understand how I'm doing this. And then to stand here and say I just gave it to him is preposterous. In addition to that, then we go to the first one, Mr. Bean. Mr. Bean testified for days. This case, Your Honor, has taken so long. I don't know how long he's on the witness stand. It would not shock me if he was there for 3-4 days. All he said was, I don't recall. That's what he said. I don't recall. Did you say this? I don't recall. I don't recall. So the state got in his prior statements to Detective Quinn. Well, I impeached him. He gave me a statement on recording. The state then doesn't ask Mr. Bean in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me, doubt. I have no evidence. And then in the middle of that document says that Brian Steele and his investigators, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Ms. Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected outrageous. Outrageous. It just flows right through. The same way Ms. Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. It is offensive. The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you for clarifying that. Yeah, when Mr. Steele clears the area. Yeah, go ahead, Ms. Love.
Thank you, Judge.
Do you have any Georgia law that represents what you have asserted in your motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and
Which I just
it wasn't.
got a copy of.
Yes.
Okay.
And also, I just
So
want to say that
no Georgia law that.
right, Georgia law does not define. It does not define case in chief. It does not break
We
it
all know
down.
what a case in chief is. Don't we? I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Your Honor, what I have said and what I maintain is that one, there is an absence, and I'll point the court to 3 different cases, Harris versus the state, 314, Georgia 238 as one. And these are just instances.
238? What did you say?
Yes.
What are the other two, and what are they going to represent?
307, Georgia, 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
When is that from?
I'm sorry.
What year?
Oh, just 1 second, Your Honor. That's a 78 case.
Okay, so that one's not relevant at all.
Old case.
Because we have a new evidence code since 78. So, okay.
And Your Honor, even with respect to the older case, the only thing that I was citing Phillips for was the proposition that in the absence of specific legislative or decisional case law on the particular issue that is at hand in Phillips, we commend the Federal Rules of Criminal Procedure, Rule 16, for guidance. That is,
Well, we've got a specific rule here now, don't we?
well, when you say we have a specific rule, is the court speaking of the discovery statute that says,
That's what we're talking about in
I
this
don't
motion, right?
right, yes, Your Honor, we are talking about that. And the state's position, the state maintained, first of all, let me be real clear, we didn't file a brief. This is the first brief that we have filed where we've asserted these things. We have asked that the court require Mr. Steele to turn this stuff over, but we've never argued it out. Mr. Steele has stood up and said he's not required to, and he has pointed to the discovery statute. The court has said, okay, yeah, he doesn't. And we put that in our motion to the court that the court has previously made a ruling that we thought deserved a second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we assert based on Waddell, and Waddell also speaks about work product, and it makes this distinction between factual history and work product and what the state or is and is not entitled. The state stands on its assertion regarding what the requirements are because of the fact that I understand the court's position that there's no misunderstanding about what case in chief means in Georgia. But as there was this expounding on its meaning in Waddell, I think it's important to recognize that there's not been a similar sort of expounding in Georgia, and we can all presume or take for granted that it just means when the defendant
When
is
you're
putting up his
presenting your
particular
witnesses.
case. Right.
Okay, so do you have any case law
In Georgia,
in Georgia that supports the position you took in your motion that reciprocal discovery requirements are triggered based on whether you're presenting something as substantive evidence? That's my question to you.
Your Honor, the only, what we have in support of the motion is cited in the amendment and in the motion itself. We have not ever presented or represented to the court that there was a Georgia case that addressed this issue. And the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, what case in chief specifically.
So you were telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Your Honor, I'm representing that. That was the position that was taken. That was what was analyzed in the cases that we have cited in our amended amendment and supplement to our motion to compel. That is, in our position, a reasonable interpretation. And as we've said in our filing, Your Honor, there was the requirement in Waddell that anything that was within the defendant's possession, custody, or control, where the defendant intended to use the item in the defendant's case in chief, that be turned over. The Waddell court, Your Honor, in analyzing the meaning and understanding of case in chief, as the court correctly pointed out earlier, said that if it is going to be used as both impeachment and substantive evidence, that constitutes case in chief. From there, we made the assertion, the state's position, that if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position.
Right. And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before. So
I don't mean in writing. Y'all have not had any discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted. I've never made this distinction. I've never said that that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms.
Your
Leaf.
Honor, respectfully, I take it very seriously.
Yeah, folks. When a judge tells you, because this is lawyer speak for, don't you ever do this again. And Miss Love can't help herself. She claims to this judge that she always takes her candor to the court seriously. This motion she filed shows Miss Love doesn't care about candor to the court. Miss Love believes she is correct, and no judge anywhere can say she's wrong. Well, they can, but Miss Love doesn't accept it. She never does. So Miss Love showed her true colors on day one for this judge. So that is a positive. But the wording of this judge is something that most lawyers with an intact brain knows. I did a boo-boo. I need to be silent. But not Miss Love. Not Miss Love.
Okay, so anyway, we'll be abiding by the discovery requirements set forth in our statutes. And Mr. Steele, thank you for the clarification. All right, I think that brings us to the issue of when we first met, Mr. Short had suggested that there might be, well, I don't know if it was Mr. Short or Ms. Love, honestly, one or the other of you. We discussed the possibility that there might be outstanding discovery that maybe actually was required to be produced that either was missing or just hadn't been talked about. And I wanted us to kind of go through in detail what it is that everybody thinks maybe the other side has that they're entitled to that they haven't gotten yet. So are we in a position to be able to do that now? If not, we can do it tomorrow or the next day and we can move on to, we've got other stuff to do too. Which exhibits have actually been admitted, if that's an easier one for this afternoon? Which would y'all rather? We got to do them both, so I don't really care which order we take them in.
Speaking for the majority on this side of the room, we'd ask if we could take that up tomorrow.
Okay, so can we do then today? I think Mr. Steele provided sort of as a starting point, a list or a chart or a spreadsheet or something of his understanding of what exhibits have actually been admitted. And for us to take this pause is a good time to make sure we're all on the same page about that. And I know that Ms. Weaver, the court reporter, had at least provided to me, but I don't know whether she copied y'all or not, a couple of places based on that chart where she thought she wanted some clarification, or she thought maybe it had been talked about but not actually admitted, so we can go through all of those. Do y'all have that, or do I need to get y'all that?
Your Honor, we have that. I believe that might be a rough draft. We have been keeping a list as well, and
Okay.
have been referencing the recorded proceedings to ensure that we are accurately keeping note of what has been and hasn't been
All right.
admitted. As I stated earlier, there have been instances where it is improper that evidence has been admitted, it has been tendered.
Right.
That has not been the case. So we are still, and we would ask that the court allow us to get a little bit further along in checking all of these exhibits.
All right, so
What has really and truly been admitted.
so the question was, do y'all have the kind of response from Ms. Weaver about her take on a couple of discrepancies? Okay. Ms. Persfield, could you share that with everybody? And I was hoping that we could do this today. If the state is not ready to yet, you know, I want to try to take us to the end of the day because we have a lot of work to do. Maybe there's something else that we still need to cover that we could cover today.
Judge, we are going through each piece of evidence, and we are comparing our record
Okay.
with the actual physical piece of evidence that we have submitted or defendant has submitted. So that endeavor is
I'm sure it's time consuming, voluminous.
and we have endeavored to make certain that it's accurate. So
Well, that'll be helpful. We would want that. All right. So, Ms. Percival will email out to y'all all the couple of comments that Ms. Weaver, in her looking back, believes might be inaccurate on the chart that Mr. Steele has put together and shared with everybody. So y'all can take a look at that. We can deal with it tomorrow. I know one thing that we're going to need to sort out. Ms. Weaver had mentioned that there are times when, and I think she said it was, I don't know who, but somebody on the defense side, or maybe more than one person on the defense side. I don't know if the state's doing it as well or not, but you will approach a witness with a laptop and show them something on the laptop and ask them about it. And that it is difficult for the court reporter to then sort out what was that exhibit actually. And I don't know if anything has been admitted that way, but I do know that the prior judge, there is an administrative order filed in April in this case that requires all evidence offered by any counsel be submitted to the court in physical form and marked as appropriate at the time of its admission for it to be properly made a part of the record, and directing counsel to provide physical copies to the official court reporter, who now obviously is no longer Ms. Weaver for going forward. It is going to be our new court reporter, Ms. Winfrey. But we actually need, electronic copies too, but we need something that is physical, whether it's on a jump drive or a flash drive, or whether it's a piece of paper. There's no way for the court reporter to capture sort of, I guess, a screenshot, unless y'all take a screenshot of the screen that you're showing the witness and then give that piece of paper or electronic file to the court reporter. That would be fine, but there has to be something that represents whatever you showed the witness on the screen. Okay, does everybody understand? Anybody have any questions about that? Okay, so we can take up tomorrow, after y'all have had a chance to look at it, the couple of issues that Miss Weaver's got a different record than what Mr. Steele does. And then I would love for y'all to be able to get together on, if there's no discrepancy, then we don't have to worry about it if everybody's on the same page. But if there is a discrepancy, if y'all don't talk to each other, maybe you could just email each other. Here's where we think there might be a question or an issue, so that we all know before we talk about it what it is that we need to talk about. So can y'all do that this evening? Don't ever, thank you. Okay. All right, very good. All right, the state has provided an updated witness list, which is still fairly long. And I would like to know from the state, does that list include, is that just the witnesses that have been called yet that still need to be called, or does that include everybody, the witnesses who have been called and those who are still to be called?
Your Honor, that includes the witnesses that need to be called. Some have already been called, but
Yeah.
those are everyone moving
Yeah, there
forward.
were a few you highlighted and said we may recall these. So that is 105 or so witnesses still to go. Then.
Yes.
Okay. And is that with y'all narrowing it down and picking only the witnesses y'all need?
Yes.
Okay. Well, we'll see. But all right, are there any other, we've got to figure out how we're going to deal with Mr. Copeland's sort of redo. But are there any other motions that I haven't gotten to yet today or mentioned today that are outstanding?
I emailed Your Honor's chambers regarding motions that I filed, and because I did not have access to Odyssey and I could not pull them off the internet, and I did not have the file copies on my computer, I identified what they were, but they were noted. Essentially, I would think they're titled notices of objection. They were regarding, Your Honor may or may not know this, there was a wiretap in this case. There's, and then also my client's phone, actually 2 phones, were extracted and dumped. So there's numerous phone calls, texts, emails, things of that nature that are on either the wiretap that were intercepted, some with my client as a part of those communications, some not, as well as all the things that are typically on a cell phone that deal with someone's essential life on an electronic device. The state has, to my knowledge, not identified what they plan to use from either of those sources of information at this time. And that's why I labeled it a notice, because there is irrelevant information, there is prejudicial information, there's on the wiretap, not so much Mr. Stillwell, but there's other individuals on these wiretaps discussing all sorts of other acts that have nothing to do with this case. And so there's just a lot there, and we're going to need to have that discussion at some time.
Okay, thank you. When does the state intend to let the defense know what it is they're actually using out of the universe of all possible things?
Your Honor, what I think that we have represented to the court previously is that prior to, I believe we said at least the week before, because there is a large volume, to say the least, of calls within the jail calls and within the wiretap that are that have been turned over in discovery. And I believe that we had previously said that did we say 2 weeks before we intend to use them, we would apprise defendants of their which ones.
Can y'all explain to me how you are dealing with a large volume of what ought to be motions in limine while in the midst of trial? And still being in any way efficient with the jury's time? You're not, essentially. Okay. All right. That's just not practical. I mean, we're going to change that going forward. And I'm not going to say I need you to know everything tomorrow because I know it's a voluminous case, but y'all been putting this case together for 2 years. And you ought to know, I mean, you clearly know what witnesses you're going to be using. And you've given me, you know, kind of a very broad idea of what exhibits you intend to use with those witnesses. But I don't know that if we're just every other week saying, okay, let's figure out all of the evidentiary issues that have to do with the next 2 weeks worth of witnesses. We can do that in one day on a Friday. We just can't. So we're not going to be able, I mean, we all know that we've got this week, and we know that the jury has already been told before I became involved that they essentially have the week of, August 19th out. So, you know, this week might be taken up pretty much with sorting out the 2 things I just mentioned and then sorting out all of the evidence that goes along with Mr. Copeland, because he's our next witness up. But the week of August 19th, we need to be plowing through a whole lot of other evidence, not just what's coming up in the next 2 weeks. We need to be covering the next several months, which ought to be, frankly, the end of this trial by then. I mean, it should not take another 7 months. It shouldn't. Whether it does or not, I don't know. But so the state needs to produce in much more detail a much more winnowed down but comprehensive list of what the evidence they intend to use with each witness is going to be, so that the defense can see it, evaluate it, make whatever evidentiary objections they have to it, and the court can have some time to view the evidence, listen to the evidence, whatever the evidence is, and evaluate the evidentiary issues, so that we know by the time the witness gets on the stand, here's what is coming in. I mean, for the most part, it's a trial, but what's coming in and what has already been excluded. So do I need to be more explicit about that? Or do y'all understand your marching orders?
We understand what the court is asking.
All right. So I feel like I need to be more explicit about it, even though I know y'all understand. By the beginning of next week, I want to see, you know, at least the next 30 witnesses worth of evidence. Okay. And then maybe by the end of that week, the next 30. Okay. All right. And we're going to plan to be here all of the 19th. And I don't know when else we're taking breaks, but okay. So that's that.
Can I ask a clarifying question, Your Honor?
Yes.
And Ms. Adams and I, Attorney Adams and I filed, I think that motion, it was not helpful to just say like witness Kenneth Copeland, jail calls, social media. I think you just covered that though.
Well, you know, in fairness to the state, I do think that when I asked them for that, I said kind of broadly, let me know what evidence. And now I'm asking for it in more detail, just because practically speaking, in the middle of a trial, we've got to sort out what evidence is admissible, and ideally not while the jury's sitting there waiting on us.
That's perfect.
Okay.
We appreciate it. The specifics will make us roll better anyway.
Yeah.
Thank you.
All right. So any other motions that are still needing to be addressed? And y'all, it's 3:30 and I plan for us to do work until 5:30, and we can take a little break, but I'd really like for us to figure out something that we can make some progress on for the next 2 hours. So let's take a 10-minute break, be back. Well, it's 3:34, be back at 3:45. And y'all think in the meantime, all right, what can we use this time productively to do? Thanks. I'm just coordinating. It's just somebody on the side of the courtroom actually has some kind of speaking relationship with somebody. All right, attorneys, try to be back by the time I say be back, okay? Try to be back by the time that I say to be back.
Yes, Your Honor.
Thank you. There we go. Because I want to be efficient with y'all's time too. Okay, did anybody come up with anything else that we can be productive about today? All right, what is it?
I don't think my mic works that well, so I'm going to come up here. There are, way back when, and we're looking for the filing right now.
Okay,
There's back in, I would estimate, June of 2023, maybe. There was discussion that we needed to know all the alleged co-conspirator statements that the state intended to use, as well as any and all extrinsic acts that the state intended to introduce evidence of at trial. My recollection, and I would defer to that filing, was that there was only three 801D to E
I don't know.
co-conspirator statements.
Okay,
There was only three listed, and then there was also a certain number of extrinsic acts
Okay.
that were listed. Throughout this trial, the state has gone past that list, and that has led to much delay and litigation and sending the jury out.
Hello, folks. Just wanting to inform I'm leaving work right about now. I will be home in maybe 20 minutes. So I will keep this playing, and you will see me as soon as I get home. Okay?
So I think that's something we could discuss.
Okay.
What if that is the entire list, which I submit it should be, we could discuss that. Also, there are, and I don't know if this falls under the discovery that we were going to talk about tomorrow, we are missing the reports of many experts
okay,
that the state plans to call, is my understanding. Also, Your Honor, there are, in this case, the state, I believe, has announced that they plan to call 5 different gang experts.
and they've called 3 at this point, is that right?
I believe that is correct. I believe
Okay.
it's 3.
So maybe explore what, if anything, the other 2 are going to add?
And not only that, but the state has announced the intention to call a few of them multiple times.
Okay,
So that is another issue that's continuously come up in this case. Am I missing anything from our list? That was it? Okay.
okay.
So
all
those
right.
are the
Okay.
issues that we came up with.
Thank you. All right. And if the state needs the evening to, sort out everything and make sure that you're being inclusive in answering to the extent you know, that's fine. But if you know now, that's also fine. Do they have notice of all the different co-conspirator statements that the state intends to use and the extrinsic acts the state intends to use? Y'all can answer now, or y'all can say, give us till the morning.
Your Honor, I'd ask the court to just give me a moment. We're pulling up the.
Okay. All right. And while y'all are looking, I'm just going to make a general sort of admonition to not the parties in council, but anybody that wants to come in here to watch this case and I mentioned it before, but I don't know, I may have to mention it a couple of different times. I don't expect there to be frequent up and down, in and out. That's distracting. So try to keep that to a minimum. There shouldn't be any talking in court other than the parties maybe whispering between the attorneys and the clients in the court. If you're watching the case in here with us, and you need to say something to somebody else, step outside to do that. There doesn't need to be any it's just distracting. There's a lot going on and there's a lot to pay attention to. And when we've got other conversations going on, it's that much harder to focus on what we and I need to be focusing on. And I also want to make clear that the deputies in here have my full authority to manage this courtroom. So if they give you an instruction, you need to abide by it. Okay. And I'm not talking about or to anybody specifically in here right now. Just some things I've noticed so far. And I, again, will probably make that announcement a couple of different times in the upcoming weeks so that everybody is clear on what the expectations are. Yeah.
The co-conspirator statement notice.
To whom should you what? Send it? Ms. Percival.
Your Honor, to the extent that the court's question was specifically, have we noticed the defense of the evidence of intrinsic acts. Is that the question of the
Well,
court
no,
asked?
I mean, maybe it wasn't very artfully formed, but to the extent you can, to the extent you know, and hopefully you know since you're in the middle of your case, I would like for you to make sure that you have given the defense notice of whatever co-conspirator statements you intend to use, and then separately, whatever extrinsic acts you intend to prove.
Okay.
And if you want to do that now, that's fine. Otherwise, that's something we can go over in detail tomorrow.
Judge, I'm looking at simply, I'll start with just the intrinsic acts, and I'm looking at 51 of them. I'm not sure about the 3 that were referenced, but within the intrinsic act notice that we filed on November the 6th of 2023,
Okay.
we made specific references to 51. And we also said acts contained within this non-exhaustive list. We referenced that the list was non-exhaustive, and we noticed the defense of the state's intent to introduce evidence of these particular acts. If the court will permit me one moment, I just wanted to call the court's attention to the November 6th.
Okay. So given that you noticed 51, but said it was non-exhaustive, that sounds like there might be others. So at this point, can you make the list exhaustive?
Yes.
Okay. And then the 3 was co-conspirator statements. By tomorrow, what all the co-conspirator statements are going to be, and then how much time do you need to make the other list exhaustive?
Okay. So, Judge, what we're discussing is the number of co-conspirator statements that may be contained within the jail calls that we are also, jail calls and the wiretap calls that we are intending to introduce. And so, to the extent that we reference simply what we filed, we can present that, but we would ask the court to allow us to address on the week that the jurors are out. The 19th?
So if it's anything with Mr. Copeland, that needs to get dealt with this week.
So with respect to Mr. Copeland.
Sure. Go ahead.
With respect to Kenneth Copeland, will the court permit the state to address in its entirety tomorrow the ones that we are intending to introduce? As we're discussing, those statements are contained within the videotape interviews and jail calls that we have intended to introduce and have noticed defense of our intent to introduce. So in terms of what the specific statements are, I think we would best be.
Okay. So does everybody from the defense understand, at least with regard to Mr. Copeland, maybe not in detail, but what the universe of potential statements is for Mr. Copeland?
So
I mean, y'all had gone through a lot of this and hashed it out once already, and you might not have gotten through everything, but y'all had done various statements and gone through in detail on what was in and what was out. And I know we might have to do that over again, and then there are jail calls that y'all had not reached yet, but I think the state had represented, there were 5 or 6 of them, and y'all know which ones they are. So that y'all all know, right?
So we know about the jail calls,
Okay.
that assuming that the state's not expanding that list.
They're not going to be expanding that list, are you? Copeland, no. Okay.
And when they say notice of things that are in a statement or past statements, I am aware that I'm not aware of any co-conspirator statements by Mr. Copeland I'm aware of the Garlington to Copeland
Right.
statement,
Yeah.
but
From Mr. Copeland himself.
I don't, when they say they've noticed us on statements by Copeland that are in his statement, in his prior statements, I don't know what that
Right.
means specifically.
Okay. So are y'all including within that, like here's what Garlington told me?
Yes.
Okay, so, all right, so that y'all do have, and are there, how many of those are there?
How many statements of Garlington to?
How many co-conspirator statements from any alleged co-conspirator are there that y'all are going to be introducing through Mr. Copeland? Or potentially introducing through Mr. Copeland?
At least 3 co-conspirator statements, 2 from Garlington that is contained within the June 10th interview. And then there's a jail call with Mr. Copeland and other unindicted co-conspirators as well.
Okay. So defense.
If there's more, we can correct that tomorrow, but.
Okay. All right. So take a look at it tonight and make sure. Okay. And then with regard to the other acts, do you want me to set I think it would be a good idea to have a deadline for giving the exhaustive list over. So do y'all want to make a suggestion as to how long y'all need to do that?
Just 1 second, Your Honor. Monday, Your Honor, is that?
That's great. Yes, that'll work. So that'll be Monday, August 5th.
For the intrinsic act.
Yes. Okay. Moving on to discovery reports of state's experts. Did you know specifically which reports or which experts you feel like you're missing reports from? Okay.
Your Honor, I just asked my coworker that I'm privileged to work with to email to your Honorable Court's coworker and everyone else the November 17, 2023 written order on this topic. And I don't know if this court has seen it because, and if you want the court reporter to be emailed out, I didn't do that either. Apologize. But we had a hearing on this on or about August 21, 2023. Opening statements were approximately November 27, 2023. And we have no reports of any gang expert. We got a PowerPoint the day of testimony from the first witness is my memory, but if I'm wrong, I apologize and please correct me. And that PowerPoint had to be gone through and had to be excised. His name is Detective Belknap, which is Belknap. Then Detective Dennis testified. He was allowed over strenuous objection to say that we did this work and we spoke with witnesses and we spoke with victims and we spoke with co-conspirators and we spoke with people who identify themselves as a gang member in IF or a gang member in YSL. And based upon that, we know that the following crimes occurred and here's some 911 calls. I don't know who these people are. We have no background. That's a conflict, in my opinion. That's a confrontation clause violation because it's the police officer doing the work. We never got any reports. When I've asked for the reports, I was told that that's under lock and key by the City of Atlanta Police Department. And he, meaning Detective Dennis, no longer works there and cannot get, they have a gang book. He described it as a gang book, but they can't get it. Detective Belknap said he cannot get access to give out that gang book. So we're basically in the dark and we're hitting as best we can. But this is all over objection. I have no idea how to challenge. Like you heard earlier today, there's a lot of information for the court, but you heard earlier today that, God forbid, it's at 7:22 p.m. The 911 call goes out and Mr. Donovan Thomas is shot. He's killed. It's on video. It's bad. It's a drive-by shooting. He gets shot. Multiple gunfire. 2 other people shot as well, but thankfully not fatally. Within the next several hours, so it's 7:22, so within 5 hours, Mr. Copeland says that abodes that are close to his family members, and you heard a representation that Mr. Williams, they said stepfather's home was shot. I have no idea who shot that stepfather's home. I have no idea who to speak with about it. There's a 911 call about it. I'm not conceding that it was done by a gang member. That's why it's impossible to cross-examine. The next witness, who was deemed an expert by Judge Glanville, is a Detective Gaither, which is Gaither. And she testified as well. I didn't make a report, but she goes into, I spoke with people, they're unnamed people. It's the same thing. I would like to know who these people are because I'd like to talk with them. Because if they say, no, I never said that, that's important for the jury to make credibility determinations. That has all been kept away from us. Judge Glanville ordered the state, and it's just, it's easy to read the order, but I wrote the order after the argument, but he signed it. In order to permit a meaningful opportunity to cross-examine, all expert notes, reports, documents, statements, basis of opinion are required to be disclosed by each expert for the prosecution as to the underlying facts or data so cross-examination can properly, lawfully, and constitutionally occur. And that's right out of the case of Harris, Harris versus State, which is 314 Georgia 238. It's in Division 6A, is in Elisa 875 Southeast 2D 659 2022 case, where our Supreme Court said that is not the rule in Georgia. But we encourage trial judges who can control the proceedings to order that to be done, and Judge Glanville ordered it. The state never gave us those witnesses. Then you have Detective Belknap talking about, well, at APD, meaning Atlanta Police Department, we have six criteria that we designate someone a criminal street gang member and a criminal street gang. Then you have Detective Dennis. He gave those same policy requirements. Then you have Detective Gaither. She gave the same ones. It is my understanding that the next two, which is Detective Underwood, which is UNDERWOOD, and she's going to testify, I assume. I don't know because I have no reports. Similar policy. And then you have Investigator Viverito, which is VIVERITO, also with the City of Atlanta Gang Division of their policy. All of this is cumulative. All of this, I have zero, none of us has any type of documentation. And the way I understand the rules, an expert, yes, they can rely on hearsay. They can rely on the opinions of others. I understand that. But when asked and when you testify, you can challenge those opinions and those statements. So you have to know who said them to you, and all that has been kept from us. So that is, I filed a subsequent motion that it's cumulative, that how many experts you need. Judge Graham said, it may be getting cumulative, but he did not rule that way. But he said this could be getting cumulative, but he allowed the next expert to testify, which was Detective Gaither. And then, I don't know how we have no reports when there's a written order. We have zero on it. It's hard when the expert is just saying, or the witness is just saying, well, I do this. I'm on the street. I know these people. Brian Steele, you don't know how streets work. And I go out and this is how I get information. People will talk to me because they know that I won't put it in a report. Well, that makes it pretty hard to say, well, I don't think the jury should just rely on your word. I'd like to know who that witness was. Well, I'm not able to tell you. I don't want to tell you. I can't tell you because I left the office. That's the issue I'd like you to address.
Okay, well, I mean, I understand the frustration. If there is no report, there is no report. But what was the date of the order that Judge Glanville issued that you referenced?
It is, and it was emailed to your Honorable Court's coworker
thank you.
at 11, which is November 17, 2023.
Okay, 24,
No.
23, 22,
23.
23. Okay.
Thank you.
All right. And that's, unless I specifically change what's been directed in an order, all of the orders that have been issued continue to apply. So I'll expect the state to abide by the requirements of that order. And we'll have to address whether the other experts might be cumulative. Besides these gang experts, are there other experts who you believe there should be reports for that you don't have?
My knowledge, unless my mind is not working, I believe I have reports on everyone else.
Okay. Anybody else?
That's if I misspoke, that's my understanding.
For any of the other defendants, anybody believe there are other outstanding expert reports that you don't have? Hearing silence, I assume it's just those. Okay.
Your Honor,
Yes,
address the court related to this.
you may. And one thing before you start, I want to ask, and I could be entirely wrong, but with regard to the experts that are being recalled, I would assume y'all are trying to present your case kind of in some semblance of order. So it may be that right now they're testifying as to ABC count and later they'll testify to XYZ count.
Correct. If there's witnesses who were fact witnesses, so to speak,
Okay.
interested in part of the investigation.
Hey! I'm here. I'm home. I finally made home. Yeah. Okay. You don't need to look into my room. Okay, what they are talking about here is the missing reports from the gang experts that also are fact witnesses. So they are both gang expert witnesses and layman witnesses, fact witnesses, so to speak. And on at least one occasion, with regards to, I believe, Detective Belknap, they switched from fact witness to expert witness in the middle of the direct examination from the prosecution. Okay. Well, I'm here at least. Okay. This afternoon that we are recapping right now, incredible. I'm still disappointed in the judge apparently agreeing with Judge Krause that she can't on its face see something wrong with the ex parte meeting. But what happened this morning in today's, we will get there soon. There was another ex parte meeting. On Friday, June 7th, there was another secret ex parte meeting. And I have the transcript. the rough transcript, or parts of it as well. So let's go through this and start with tomorrow mornings. And when they bring up this other secret ex parte meeting, I will read from that transcript.
And they also testify down the road about another.
Okay, all right. Is that all? Yeah, go ahead. And if there was something else you wanted to say, yes.
Your Honor, just briefly, I wanted to kind of orient that as different gang experts that the state have called to the stand, this argument has been addressed or raised to Judge Glanville. And part of it is gang experts, unlike GBI experts on blood or touch DNA, the police reports that the state has related to the underlying crimes. This is obviously a crimes that span a decade. So the gang detectives, specifically Detective Gaither, Detective Dennis, they worked, I think, approximately 26 retaliatory shootings after the January 10th murder of Donna Thomas. So they worked as the lead detectives. For example, we have put evidence, you've heard about D'Angelo White. That was a shooting, attempted murder that happened that Detective Gaither and Dennis picked up after essentially an aggravated assault detective with an APD had it, because they're gang detectives. So when they talk about, they don't have, as you would have in, say, a scientific report, like a 50-page treatise of the Young Slime Life Street Gang. They have worked these crimes, and their reports or warrants that the state has have been turned over. And so the basis that they state their opinions to the, they speak from working the case, from talking to people. So
they're
that's
experts based on their experience.
Yes, Your Honor. And part of the issue arises is the reports that the defense is requesting, they do not have. And so, for example, I believe it was Detective Gaither and or Dennis, they mentioned, they are retired from APD. So when you ask them, well, do you have some other additional reports? They say all the reports I made, were in my file. So the state is not aware of any reports from these gang experts that we have that has not been turned over. The state believes that those kind of four corners from this decade of acts in the case don't exist, of like Detective Gaither or Dennis didn't write some large report in total.
Okay. Has the state asked, not the individual detectives who have since retired, but APD? Do we have all of the reports relevant to this case?
Yes, Your Honor. And I will defer to my co-counsel because I came on this case in December, but my understanding is that that has been Chief Deputy Love or Hilton, correct me if I'm wrong, to the court.
No.
Yes, Your Honor, the reports, this is an issue that has been addressed multiple times after the order was entered. Every time that we address either Gaither, Dennis, or Belknap, the issue is raised that there is an absence of a report. Judge Glanville, the court can search the transcript for this. Judge Glanville has addressed repeatedly Mr. Steele's.
Yeah, here's the thing about Ms. Love's argument here that I find incredible in the worst possible way. They have reports from everywhere except the gang experts. These are, and they have brought up retired police officers. They have, their reports are there. But these gang experts reports, the police reports, because they would lead detectives in some of these crimes. But they are all missing.
Motions and his assertions regarding their lack of a report from various experts. I asked that the court review that portion. You do a search for the word expert or report.
I'm not going to do that. Sorry. I mean,
no, I don't have any problem with that. Not only is that we've addressed
I didn't have to read.
we've addressed that issue multiple times.
Okay.
And Judge Glanville has ruled on Defendant Williams' repeated motions for a report of detectives Gaither, Dennis, Belknap, our gang experts. Judge Glanville has ruled on that even after the order that was entered. So I don't believe at this point that there is any further ruling unless the court wishes to reconsider the rulings that Judge Glanville has previously made. I don't believe that there's any further matters to be ruled on as they relate to expert reports and the gang experts that the state has identified for the defense.
All right. Just make sure that you have abided by and continue to abide by the order issued on November 17th, granting the motion for complete witness list and expert reports and analysis and findings. Okay.
Your Honor, may I respond to that briefly?
Yes.
And I was going to provide one case to the court.
So,
before, after.
okay. All right. Yeah. No, we'll let Mr. Atkins finish. Let me, and Mr. Steele quoted it for us, but what the order says is all expert reports, their analysis, findings, and the basis for same must be provided to counsel for each person accused instanter, which means immediately. So the way I read that, that means even though this goes beyond what our discovery statutes might require, this order is what controls. And so even if there is not a written report, you need to give to the defense any findings that these experts have made and the basis for those findings. Okay, just make sure y'all understand that.
Yes, Your Honor.
Okay, go ahead.
The case, and I apologize, but it's Hassan v. State. which is a March 19, 2024 Supreme Court of Georgia, HASSANV state. The version I pulled up is from when it was just pronounced. So it has,
What's the
Site-
S24 number?
it is, Your Honor. So I need to pull up another version. I have the version I saved when it first got published. So I have a 2024 Georgia Lexus 7.4.
Well, that'll work. 2024 Georgia Lexus
7.4, and then it gives a Westlaw.
7.4?
Yes, Your
All
Honor.
right, I don't use Whistle.
But what I
I
wanted
used
to,
to. I just don't anymore.
I've only used primarily Lexus, Your Honor.
All right.
What has came up
Mhm.
briefly in defense counsel argument, but gets brought up is this case is important because it discusses when, for example, gang detectives are speaking about. Typically, experts can talk about or rely on hearsay
Right.
to make their expert opinion. So when you have gang investigators who have spoken, talked with a number of people, part of their response or expert opinion on XYZ is based on years of experience. And so this case has an important holding in relation to specifically, neither witness expressly repeated the out-of-court statements of any other person, although the detective testified that he was familiar with the Ramsey investigation, which was some other investigation he was talking about, and referred to speaking with another detective who worked on it. He did not specifically state what the other detective told him or how he developed his familiarity. So it was not obvious that the evidence was hearsay, such that the trial court should have sua sponte excluded it. And this was a gang case where, kind of like how Detective Gaither, Dennis, and then Detective Viverito down the road, they reach their conclusions. And so if they are not directly deriving what their statement is from hearsay, as an expert, this case is helpful to illustrate in the context of a gang expert, how that can come up. So I just want to share that, Your Honor.
Appreciate it.
Thank you.
Yeah, some expert has already testified with an absolute lack of reports, which made it absolutely impossible for the defense to impeach them about things they might have written in their reports. But the judge allowed it anyway. Or Judge Glanville allowed it anyway. Yeah. Auntie M, I kind of like this judge. She needs a soundbite like, denied, sit down. Oh, that would be good. Let's continue.
Thank you, Mr. Sharp.
So, Your Honor,
Yes.
I don't want to be taken as crying over spilled milk, but I'm really just trying to bring things to your attention. Miss Love referenced in kind of, I feel like I was the one that was making the most noise about the reports, especially investigators' reports. And the reason I was doing that, and we're not talking about expert testimony right now, reports by an expert.
Mhm.
These experts were also testifying as fact witnesses.
Right.
And there were several times, there was Investigator Gaither, and I believe it was Investigator Dennis. I could be wrong on that, but it was definitely Investigator Gaither and another investigator. I think it was Dennis. And they testified to doing things in these cases.
Mhm.
And we're looking at a lack of reports indicating that these tasks were done, showing photo lineups to certain people, interviewing witnesses. And I complained about that. And I said, well, where are the reports? Because at first I was, in cross-examination, well, wouldn't that have been something you would write a report about? And they said, well, we did write the reports. And so we met out in that side room with Investigator Gaither, but I believe Investigator Dennis, we also talked to him, and they insisted that they wrote reports about this work. And it is correct when they said, when we left, we're retired, we cannot access the reports, but we left them with APD.
Okay.
The state has stated that they don't have these reports.
All right. That should not be happening. We'll take that back up when she comes back in, whoever she is.
The state has stated repeatedly that they don't have the reports. And I think all of us are left in this quandary where the state's saying they don't have reports, but the witnesses are saying we wrote reports. And
Okay. Do you have dates for any of that? Or have you previously discussed with counsel for the state
when I brought this up to,
what you think is missing?
yes. Well, unfortunately, those witnesses have already testified. So of course I would like the reports, but going forward, and the part of my frustration is when the state says, we don't have reports, and the witnesses are swearing there's reports.
Right.
So we can't really nail the witnesses on it. And the state's saying, well, we can't hand anything over either. Then we talk about it. And the court at the time just kind of said, well, there was a hack in 2018. And
That's actually what I was literally about to say is it's possible that for some of these things, I mean, we all remember we were all around in.
Yeah, apparently in 2018 there was a big hacking thingy in the Fulton County database. But it's still, isn't it very suspicious that the report of every other cop exists and the evidence attached to the gang experts' reports is not missing because the prosecution have used it. But The reports themselves are missing, but only for the gang experts. What a strange coinkydonk.
2018, the city of Atlanta there was some huge cyber attack, and lots of things got disappeared from everywhere, wiped out. So if that is the excuse for some of it, it's probably legit.
Well, I'm not
It's
saying
gonna
it is
depend on
or
the
isn't
dates.
legit. I'm not saying it is or isn't
Right.
legit, but
I'm happy to bore down on it some more and talk
Because-
specifics.
I mean, it wasn't even, I can't recall if that was even suggested by the state, but that was just thrown out there. Well, reports are missing because of the hack. And I'm like,
Well,
how do
I'm
we know that?
happy, yeah. If you want to get together a list, and I mean, maybe more so for the witnesses going forward, and these, we're at this point not really talking about expert reports, we're talking about police reports, fact basis. They ought to be out there. And if you want to in detail get that, because that is frustrating for everybody. I mean, yeah, it's out there. You wrote it down. So unless it disappeared in the cyber attack, it ought to still be able to be gotten, even if not by that witness, because that witness is retired, by the state, because the police and law enforcement are a part of the state. And so it is within the control, if not the custody of the state. So I'm happy for us to bear down
least
and
the
bore down
note-
and drill down some
the
more
note
on that. If y'all want to give me
has to be
specifics, or if you want
clear.
to, well, give both to me and share with the state specifics, because that will help them as well to not just say, hey, APD, please give me everything about this case. But there should be a report from Detective Gaither dated August 2nd, 2000 about a lineup she did. And then they can actually search for something. So let's, to the extent y'all want that, and you're certainly entitled to it, let's get details together so that we can give that to the state, so they can give that to APD, and we can actually hopefully find something if there is something out there but missing.
Yeah, Sean. thank
Okay. All right. Yes. Yes.
Turn it over to defense. Every report from 2015, every report that the experts have referred to or will testify about, and the complete case files that exist for each of those reports.
Okay.
So we've turned that over. If I will
That's a lie.
await defense giving to us what they now posit they don't have,
Okay.
that we have not already addressed.
Okay.
That again, Miss Love is lying to the court because she can't help herself. She has to lie because she hates looking bad. So again, she lied to the court because when that was addressed with Judge Glanville, I remember this vividly, that she said they have looked for the reports, they have asked for whoever is in charge of keeping the record, whatever's, and they can't find it. So she acknowledged to the court that these specific reports are missing.
And Your Honor, I am asking the court to refer to Hassan versus the state, 318 Georgia 673. It's a 2024 case. That's the full citation of the case that
Okay.
Mr. Atkins just.
Oh, perfect. Thank you.
Your Honor, I mean, with all due respect to everyone here, that's a bit disingenuous
I think
because
is your mic on?
I'm turning it on.
Maybe we need to take a look at that and see if it's still working.
With respect to everyone here, that's a bit disingenuous to say, well, we're raising this for the first time. We had the issue in court with Investigator Gaither. The state is very aware of what those reports are. I'm not saying I know all the answers here. All I'm saying on those previous occasions, there wasn't, in my estimation, from my vantage point, there wasn't a lot of effort, and it was just blame the hack.
Okay, well, thank you.
Yeah.
And I don't want to keep going back and forth with blame or bashing. I want us to be productive and talk detail so that we can make things happen. So thank you. All right, what else? If anything that we can deal with today. It's okay to say that's about it for today, because I've got some homework anyway. All right, so we will adjourn for the day, and we will see everybody's smiling faces at 8:45 tomorrow morning. Thank you all.
Your Honor, before the court.
Oh, yeah, there's one more thing for me too. Go ahead.
There's a scheduling matter that we would like to address with the court.
Okay,
With a member of the bench at the bench.
okay, come on up. And I guess one person from each team. Before, and if we're going to be using those during the trial, I would like a little bit of practice on them before we get in front of the jury. So maybe, the next day we end at 4:30. Y'all remind me, and let's all figure out how those work, because I don't know yet. All right. Are you just going to be representative of everyone?
Yes.
Sounds good.
Okay. Guys, do you know what this is? This is Sidebar counter 216. Oh, I haven't used that in a good while. Oh, that was fun. All right. Let's skip through this because there is something interesting after here.
But we do pick back up with the jury, which hopefully will be soon, but I'm not sure yet what all we're going to get finished with this week. If we bring the jury back next week,
No,
there is a request for the court to consider having a witness who is not Mr. Copeland be the next witness because of a scheduling matter for the attorney who was examining Mr. Copeland. Now,
just before this, sorry for stopping again. Remember Mr. Melnick? He was going on vacation and asked the court if they could wait until he got back, and he was told no by the prosecution and the judge.
we have to redo at least part of Mr. Copeland's testimony anyway. I don't know if that's an issue to y'all. We're going to have to come up with whatever we're going to say with regard to, you may be hearing a lot of this again, and you're going to need to disregard what you heard before. We'll have to work on that, and y'all be thinking about that. That's y'all's homework. But is there objection to moving to another witness and coming back to Mr. Copeland? And if so, what is it? And then I'll consider whether I'm going to permit it or not.
There's an objection to going back. It's telling the jury anything about disregarding Mr. Copeland and having to do it all over again. It's impossible. There's no way in the world.
All right. Well,
The jury
yeah.
just disregard Mr. Copeland.
Okay, but that's not what I was asking. I understand that you just think that is a total disaster and makes this trial one that needs to be a mistrial. I understand. But that aside, just with regard to scheduling, assuming we are going to go forward for the purposes of this discussion, and assuming that, I mean, y'all don't stipulate to everything he's already said and that we have to redo a part of his testimony. Well, whether we do or not, we're going to have to continue his testimony. So is there an objection to essentially taking some other witness out of order in the midst of his testimony?
Your Honor.
Yes.
Keith Adams on behalf of Mr. Williams. Mr. Steele and I have consulted about that. And I don't purport to speak for anyone else. We do object
Okay.
to that. We believe that given the complexity of Mr. Copeland's testimony and the issues surrounding his testimony and the confusion that will probably already attach to a jury coming in and seeing some of what Mr. Copeland's heard and testified to and possibly having to be instructed about disregarding some of his testimony, we would object to,
Okay.
to going to another witness.
All right. I appreciate it. And I think with that objection, it's well-founded. So y'all do what you have to do with regard to who might be handling the examination, but we will pick back up with Mr. Copeland and finish with him before we move to another witness.
Would you allow another member from the state to continue his examination?
Considering that we're going to
Here we go. Remember how they vividly told Mr. Melnick that if he wasn't there representing his client, they don't care. They were going to make him testify anyway. Remember this in this situation.
have to, well, as I understand it, there are a couple of days of, and I don't know whether y'all got testimony out of him or not, or if it was just a discussion of whether he was going to plead the fifth or all of that. If there was there testimony from Mr. Copeland prior to the motion to recuse on the 12th?
Yes, sir.
Okay. All right. Considering that Ms. Hilton handled that testimony, we don't normally switch attorneys mid-witness. There is now a request on the floor to do just that, to switch attorneys mid-witness. We're switching judges anyway, and we're redoing some things. So it's a little out of the ordinary anyway, but if there are objections to that, I will entertain those.
Well, may I speak?
Yes.
I would hope that that's not as of tomorrow when you rule on qualification, so that Ms. Hilton can go wherever she would like to go. As far as I'm concerned, we will not call her for several months. Who is the witness that would be substitute? I heard it was.
Oh, I don't know. Do y'all have another witness in mind?
What is the hiatus? Is it a week?
I don't know that either.
It will be 1 week, Your Honor, will be my absence, will be 1 week. Your Honor, we do have several witnesses. It would be the state's intent to potentially just go in order of who we have kind of listed. So we wouldn't be calling anyone from the bottom of our
Okay.
witness list, but it would be someone within the same
All
act that
right. So you just essentially skip over him and go to the next witness on your list and then
Is this better volume between me and the court? Just tell me, and I will try to adjust.
And come back to him, but I've kind of already entertained an objection to that and said, no, you can't do that. So the question on the floor at this point then is if we're continuing with Mr. Copeland and not picking up with another witness in the middle, is there an objection to another prosecutor handling the remainder of his testimony and whatever needs to get redone?
We just have a vote.
Sure.
Take a good look at Mr. Shard up there, sitting down, smiling. When all the defense attorneys are smiling, something's up.
Speaking only for Mr. Kendrick. Mr. Kendrick, yes.
Okay. And on what basis? Because you want to make it difficult for the state.
No,
Which is fair.
well, no, Your Honor. This whole thing is messed up.
All right.
We've got to redo this witness.
All
We
right.
can't redo the witness.
Okay.
I don't even want to get started. So switching out the questioning attorney
All
is
right.
just even more complicated.
Okay, so let me take that part of this under consideration. All right. Okay, so the other thing that I had
Your Honor.
is I
Your Honor.
asked,
Judge,
yes,
I'm sorry.
yes.
I'm sorry. Didn't
Oh,
speak
I'm
quick-
sorry.
No, that's
Did you-
okay. I didn't speak quickly enough, or my microphone didn't come on quickly enough.
We'll blame it on that.
Yeah, it's the microphone. Just to be clear, on behalf of Mr. Williams, we don't have an objection.
Okay,
And I don't believe, I'll let everyone else speak for themselves, but I don't believe there are any other objections back here.
other than the one already voiced by Mr. Harvey.
All right, so that's just us.
Okay.
I object to Mr. Adams making me look bad.
Okay, well, so noted. All right, well, I'll think about that one. Okay, so there had been, Miss Love put on the record this morning that she had made the request for the Monday morning meeting. There was the June 10th meeting with Judge Landell and Miss Bumpus and others at some point in the afternoon of the Friday the 7th. And I said I would get that ex parte because it did get taken down. And so I reached out to
Ms. Love requested a meeting. She made the request of the June 10th meeting on Friday the 7th. That's not entirely true. Let's just say that.
the court reporter who handled that, and she has given me a rough. Now this, and I'm going to share it with each of you. It's a rough, so this is not the official transcript, but I mean, she's an experienced court reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything. Okay, so if y'all all want to come up here and get a copy from Ms. Persfield, after that we will be in recess for the day. Thank you.
So she hands out what will be a bombshell for today. Now, we are on today, sadly with no subtitles.
Productive evening last night, and I understand that the parties have a proposal with regard to at least a portion of Mr. Copeland's testimony. Sorry, I didn't have this turned on. So what I said was, I trust everybody had a productive evening, and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony. So I'll hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening, myself and Mr. Shard had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about their proposals and we can move forward from there, Your Honor.
All right, so I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well. So we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround. So we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now. Don't think? Otherwise, give me something else we can do this morning.
Yes, we can do that. If you can, we just need to get that material very quickly to the office, to the courtroom.
All right, send somebody to go do that, please. And I'm, has anybody thought through yet, and maybe we'll have ready soon, any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony. And then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I would, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right. Well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
Thank you.
Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I will get the exact language that I'm speaking of.
All right, great. Thank you. I appreciate that. Okay. Anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be.
Thank you so much, Erin, for being a member for 12 whole months. Thank you so much.
A false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, well, we will work on accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
Oh, the giant list of.
the giant list of
Okay,
exhibits.
yeah, that's fine. That can be next Wednesday.
Okay.
That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters
Yes, Your
for
Honor.
that. I
And I-
thought you meant Mr. Copeland's testimony.
No,
Okay,
Your
all
Honor,
right.
no.
My misunderstanding then. Okay.
Can you hear me now? Apparently, StreamYard decided to put me down to 50%. And I saw from Dave, I would love for half the jury to show up and say, we know what's going on. And then the judge has no choice but to declare mistrial. Yeah, but then it's a do-over. Then everything will just start all over. And they need a mistrial with prejudice.
All right. So with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let.
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things. But what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination? Or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this and we're okay?
What will happen if it suddenly becomes a mistrial is that probably this judge will preside, since she was appointed, the final part of this trial. So would the state have the same thing? Yeah, I mean, that would be a really tight ship with much less BS from the state.
Okay with that ruling?
We believe
That's
out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
I just know, we don't think there's many, at least from the state's
All
perspective.
right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before the
one.
Monday.
Sorry,
And
just
which-
to, I'm sorry, just so that we're clear for the record purposes. This is the transcript I gave.
Here we go. Mr. Shard is angry with good reason. Here comes the bombshell. Listen carefully, folks.
Y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had an in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful. Yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on at trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions.
right.
Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around. But we need to move forward with this in whatever way it's going to move forward, in a calm and professional manner. Okay. So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain.
Yeah, sadly, it seems like Judge Whitaker, in an effort to move the trial forward, will punt this new secret ex parte meeting as well. In my opinion, here was her chance to say, with this new information, I can revisit the motions of mistrial regarding what was said in these secret ex parte meetings. And when I now know that Ms. Love misrepresented that there were no others than was already transcribed, or that the court already had. Now, when I know that was a misrepresentation, I will take that into advisement. Yeah, and as MG Law says, it shouldn't have happened at all. That's the problem, Judge. Now, let's see, I believe Doug Weinstein comes up a bit later talking about his supplemental to his motion for mistrial.
Evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators.
Oh, yeah.
Going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay?
Now, it is good that the judge acknowledges that if she was handling a case and this was said about her, she would get heated. Good. That means, Your Honor, it was wrong. It was fucked up. Based on your experience, Your Honor, and you already said this, it's wrong. But I guess we have to wait and see. And here again, how do we now know there are no others? Well, on the June 7th and June 10th, Miss Weaver was there to take the notes and the writing it down. How do we know? For instance, meeting through the weekends. Miss Weaver doesn't work weekends. Did they meet during that weekend? We don't know.
And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
if I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I like Mr. Shart, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot. So
well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration, like I said.
Yeah. Doug Weinstein was on my show arguing that Judge Glanville has done his best throughout the trial. He made this mistake with the how he handled the ex parte meeting. I feel so bad for Mr. Weinstein because Judge Glanville violated Doug's trust in the justice system. And yeah, I feel so bad for him.
I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. Yeah, if y'all feel like you need to get it off your chest, come on. Now's the time.
Okay, I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was? I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know.
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, you know, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked.
Judge Glanville, a respected judge, he can go fuck himself. The only time Judge Glanville should be allowed into a courtroom if he is the defendant. He should be thrown out from his position as first.
Did every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, you know, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think
Oh,
sometimes it is possible to sort of been on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Shouldn't have said hell, but y'all, I mean, all right.
Those were not my words. Those were Chief Judge Lando's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides.
Oh, hell no. Oh, hell no. Oh, hell no. The only times the prosecution couldn't get their wishes was if the law and case law was so on point. You saw it yourself, Judge Whitaker. Prosecutor Love stood in front of you and argued that the defense should leave every piece of evidence they have to her so she can go through it, even though it's her witnesses and her case in chief. No. This has not been frustrating for both parties. The only way it's frustrating for Ms. Love is because she doesn't get 100% of what she wants, even though the law says otherwise. Oh, Judge Whitaker, no. Judge Glanville is not respected. He lost that some time ago.
I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to evidence? Mr. Steele.
Damn. Sorry. I was so getting into it. Yeah. Okay, let's start over. In the Superior Court of Fulton County, State of Georgia. I will take that up here instead so I can check that monitor and this monitor. Supplement to DeMonte Kendrick's motion for mistrial. Comes now DeMonte Kendrick by and through his undersigned counsels and brings this supplement to motion for mistrial showing as follows. Quote, outside agitator is a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider, end quote. Professor Gillen C. Pennyroth, U.S. Berkeley. Judge Glanville making outrageous allegations against members of the defense team in the present case. Quote, but I think it does in some way outside agitators and everybody else who I think are trying to influence, end quote. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to a 14th Amendment due process violation relating in part to Chief Judge Glanville's wrongly coercing Copeland to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights has just come to light. Yesterday, after court, Kendrick received a rough transcript of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th. The rough transcript was helpfully provided by this court to defense counsel. A reading of the rough transcript highlights that which has been obvious to all observers except for Kendrick's counsel for the past 19 months. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case. Kendrick's counsel takes no pleasure in alerting this honorable court to this situation, but client obligations require it. Due process requires a fair trial. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton gossip like yentas over 13 pages of transcript about attorneys Short, Melnick, and Steele. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his client, Copeland. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton attack attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland. It is not a fair trial when in an ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. It is not a fair trial when in an ex parte meeting, Glanville starts talking about, quote, outside agitators, end quote, stating, quote, my comments today were predicated on there's a lot of stuff that's going on in the background, but, and it shouldn't have to do anything with y'all's case. It really shouldn't. But I think it does in some way outside agitators. It is not a fair trial when in an ex parte meeting, Glanville and Love have the following outrageous conversation. Court. But it does in some way outside agitators. Miss Love, that too. The court and everybody else who I think are trying to influence. Miss Love, that is absolutely happening. It is not a fair trial when Glanville, Love, and Hilton have this further discussion. Miss Hilton, there's a lot going on. Miss Love, there is a presence. Yes, that is all I say. The court, but I see it from just being in the courtroom and tracking. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? This case is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. No Herculean effort by the present court can fix the due process violation of the last judge. This house must be torn down. A mistrial should be declared and retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. Wherefore, Kendrick respectfully continues his request that his honorable court declare a mistrial based on at least due process violation of Kendrick's constitutional rights under the federal constitution and the constitution of the state of Georgia. July 31st, 2024. Douglas S. Weinstein. Now, the exhibit here is the rough transcript. This is not the complete transcript, it is the rough transcript. But we need to get caught up with the hearing. So I will go through that when we get to a break, so to speak.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put it in at all. So I understand what you're doing. You know,
Okay.
we're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said yesterday. I agree that that's a law. I don't believe that it should come in at all. So before you tell us later, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but
I forgot one thing. Steve Keat for 10 New Zealand dollars says, thank you so very much, Nick, for your great coverage. Thank you so much for your support of this channel. Thank you so much. Thank you. Thank you. Thank you. All right. Thank you. Thank you. Thank you.
Just another layer of that. Oh, I'm sorry.
go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements that our stance is that those were not in furtherance of conspiracy either. So
Okay.
there's like two layers
Sure.
of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either I don't remember, or an I don't know, or well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that. And it was a flat out lie. And I'm paraphrasing, but that is what they're talking about. Correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Shard, Mr. Steele?
Yes, Your Honor.
Yeah. So that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay. And 24, the 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead.
Spoiler, it took more than a minute. The prosecution keeps believing they are still in front of Glanville. They aren't. So this is the positive thing. Judge Whitaker holds them accountable. But it seems like she doesn't want to approve of any type of mistrial. So that's the bad part.
We can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else could we do that's productive?
Your Honor,
Yes.
I would like to make records The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
I believe. If your court thinks that's a good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and what Ms. Love and or Ms. Hilton perceived and therefore caused them to want to speak to the court ex parte don't really have to be the same.
Yeah. So Mr. Melnick, because Judge said she's going to read the transcript. And in those transcripts, is Ms. Love lying about her conversations or mail correspondence with Attorney Melnick? So Mr. Melnick is in the courthouse, prepared to testify. I haven't watched that far. From now on, I have no idea what's going to happen going forward, except that it takes more than a minute for the prosecution to find the case law they should have had in their hands.
Thing, and I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland to Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that it did not go to the holding or the ruling. And she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a Honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like it was, maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, do you want to be, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make.
Okay, well, I'm going to make a
Melnick,
substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, oh, you seem to want to talk to him, so I will let y'all talk privately, which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that.
And I've said this over and over and over again. Miss Hilton contacted Copeland directly, knowing that the last time they had something to do with Copeland, he was represented by Mr. Melnick. The correct way for her to contact Copeland is via his attorney. And she didn't bother. She went directly to Copeland, and there are no texts submitted, at least. There are no emails submitted, at least. It's only Hilton's word for it that Mr. Copeland stated Mr. Melnick wasn't his attorney. Only her word. And I don't trust her.
I think that it is clear in context that what they meant by, we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interest, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally, has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he...
You don't have the full story, Judge Whitaker. Miss Hilton said in open court, on the record, not in front of the jury, that she contacted Copeland directly.
Is counsel for Mr. Copeland. It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, Lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well,
So I just want to get the record straight because Georgia law, and I gave you these cases in a footnote. Georgia law right now, and I know I'm very familiar with the Ensemble Court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding. It's over. The case, no one looks at prejudice. But the two cases that came out in April, one of them had been in January, but I cited them in the footnote of my motion to just educate
okay,
the
well,
court.
if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong,
Okay,
and we need to show prejudice,
okay. With regard to,
like federal.
give me the cases and what,
Step back.
okay,
But so I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
okay, well,
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton and Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there's not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press, I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I see, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact and we investigate. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand. And I don't know that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th? Okay, so let me make that determination.
I'd like to call him if you change your ruling. Both of them, Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this happened. I want to get it right.
all right, so you haven't talked to him yet about what, all right, well, obviously I'll give you a chance to talk to him before you make a proffer because you need the proffer to be accurate.
Okay.
All right, so that's not something we can do right now either.
Okay, thank you.
All right,
Yeah.
so what can we do? And if
Now, he should be able to make a record with Mr. Melnick's testimony. But now it is on the record that this judge denied it, which is not as good, but it's still on the record.
there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay. All right, let's come back at 11.
So the judge allows the prosecution an hour and a half to do the research they should have done before walking into court today. But she will at least read the case law the defense provided to her, and then she might do a ruling. So let's skip ahead. An hour and a half. And all of a sudden, we are only 40 minutes behind.
It's all about your direct question regarding the prior inconsistent statement and whether or
Okay, I will see if I can find. I guess I have to go to the law and C word. But they have all these. There. There it is. Okay. Now we at least have subtitles.
and whether or not the fact that Mr. Copeland said, I said it, but I lied, if that would be grounds to, would that still be considered a prior inconsistent statement? And Your Honor, I have three cases for the court.
Okay.
I have Green v. State. I have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250.
Yeah, it sounded like she made a recommendation to the defense to bring this to the Georgia State Bar. Or that she deferred to the State Bar because she wants to keep this trial going. I'm not sure.
Which is a 2023 case. Sconners v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconners, SCONYERS v. State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It's an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes,
Your Honor?
thank you.
Oh, sorry, and I'll give it to you. Give me 1 second.
Thank you.
I gave you green already, Mr. Long. I gave you green already. Which one did I give you?
Mr. Matthews.
Okay, you're welcome.
Thank you very much.
You're welcome.
All right, so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the only one I've looked at so far, is there one that says, if you say, yeah, that was a total lie?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officers interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said, a witness's failure to remember making a
All right, so hang on. You're talking too fast for the court reporter to
Sorry.
take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
And when the court, the analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia, 63 at 66, page 66 to 67. They further cite Bridgewater, which is 309 Georgia, at Penn site 887. Which cited defendants denied recollection of making a statement, provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Scaniers that discusses primarily that the state does not now have to go through every single inconsistency,
Okay.
but that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further details. That's kind of our summation of Scaniers.
All right.
And then Oldham, Your Honor, is a federal case on the same point as the Green case, Your
All
Honor.
right. Thank you. Appreciate it. Counter law, counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than me respond, like Max Sharp or someone. But I just want to state that the foundational element for this argument doesn't even exist because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't because we.
Right. No, I mean, I don't think anybody disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue. given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true. Yes, he may get up there. Who knows what he's going to say? But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was, according to y'all, and I've seen some of it, that was a complete lie, then we will face this. And so let's figure out what
So we're guessing at what he may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely.
Thank you.
Okay.
And if for anything, I do remember that there were at least 2 full days of testimony from the 10th to the 12th. And it's the state's remembrance that the I lied started early in his testimony. So, but we can.
Thank you.
As well.
And with regard to that, the court reporter has said that she probably, what did she say, Ms. Firstfield? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said by either late today or tomorrow morning, she should have, I believe it's June 10th, June 11th, and then would be working on June 12th, shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th, 11th, and all of the 12th.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked 3 questions in that.
All right.
Yeah.
So do we already have the 10th?
Heather Mosher is correct. He didn't deny most statements. He said, if that is the cops, what he put down, I probably said it. And that he lied. He also said, I don't remember. I mean, there's so much wishy-washy with all of this.
Somewhere. We'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Your Honor, I don't think that the state's cases, from what I heard, I did not read them. I just heard the discussion. What we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case. It is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember, reading right from the case, he says, Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, I'd be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement, quote, lies to try to get out of trouble, unquote, and that he would, quote, say anything, unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said 23, I meant prior inconsistent statement.
Okay.
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or testimony by contradiction. So I found this case, if you don't mind pulling up, or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. That is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. Then it says, however, the fact that the witness admits that he or she made the prior inconsistent pre-trial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, I don't want to mislead the court, it's under the former 24-983. Then I looked at Cummings, which is cited, which is Cummings versus State, which is 280 Georgia, 831. It's in Division 3. It's a 2000. Now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division 3.
Yeah, so it looks like in that case, he just refuses to answer whatsoever.
Exactly, which is really obviously, saying I don't remember, I don't recall, I may have said something. Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to arm you with it. But then we're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green controls. And whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure. Yeah, absolutely. All right. Thank you. Thank you, Ms. Hilton. That was a helpful use of our break. All right. So, with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the states as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
It was what was hashed out during
the state of it. Okay, so were those hashings out done Prior to or after the recusal motion being filed?
It was done, 3 of them were definitely done after the recusal motion was filed.
Okay. Well, the one done before the recusal motion was filed, we can go with. However, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the other, I know we were in the middle of playing 2 of them during that time period. I just need to confirm when we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. I believe we played those interviews on Monday, June 17th.
And which would be part of what either needs to get redone or y'all need to make a,
Yes,
come to agreement on.
and we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have any issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So,
All right, I'm not sure I follow you.
Okay.
So. What you say you want to revisit. So I think first it would be helpful to know which ones were hashed out before the recusal motion. And then we can just say that's what we're going with because that was prior to any issue. And therefore we can stay with that. As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So have y'all had discussions yet about, or I thought y'all wanted to figure out what was actually done and what wasn't.
and I guess maybe I misinterpreted what the court, I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that we wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection to the current state of the redactions based upon what occurred.
All right.
And so that's what I thought I understood.
Okay, and that was January 11th, January 28th.
February 20th and February 21st.
And so you will let me know which one or ones of those were hashed out before. And that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided. And if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody. Yeah. Is that true?
No, we did hash out that one as well.
Oh, you want to revisit that one?
Yes, Your Honor.
Okay. Okay.
Yeah.
All right. Can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations made as to any of those?
Pushing up to 1.25.
And respectfully, and I'm not trying to belabor the point, but I just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post serving the recusal motion at this time.
Okay.
So
well,
and we understand.
I am not going to be going back and revisiting evidentiary rulings made before them.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very.
It is disheartening, but it is somewhat good for appellate issue. I think I've said this before. If the appellate court sees there is a clear cut in how she rules similar evidentiary thingies with how Glanville did it, that in itself is an appellate issue. But that should also be an incentive to the judge to acknowledge, yes, maybe I should. But that brings up, if she finds there are several bad rulings, then there will be more motions for mistrial with prejudice. And that should be the correct way to go. But it seems like Fulton County courts protects the judges, and everybody has it in them. No matter what, the trial must go to the jury. And I believe we are so far beyond mistrial. It's ridiculous.
Very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th, and the 25th, and the 26th. Okay. Which is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations where we agreed and didn't agree at the time. So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So,
and that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
True Story asks, why isn't she ruling on a mistrial? Wasn't she supposed to do that today? I don't know. Before this break, she said she would come back with rulings, and she didn't. So I don't know. I don't know.
Okay.
I'm sorry, I don't have a better answer for you.
Okay.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Sharp just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Sharp is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this, because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other. It wasn't that long ago. So, okay.
They were writing motions to get everything as good as possible so you could make a ruling on the mistrial. Now, you have denied, I believe, 2 of them, but it's still Mr. Harvey's and Mr. Weinstein's left, and possibly others. And you don't. So, I mean, if you don't make rulings as you promised, why should they put in effort when they expect you to make rulings? Their time is more precious than yours, Your Honor.
All right, so how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Mr. Zachary. Sorry, Mr. Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over, well, we have turned over the statements that Mr. Zachary has made.
All right.
Believe that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful and consistent, but we don't know what.
Okay, so for a whole lot of this, I mean, y'all can't really, let's assume that he testifies. Let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, well, let me look at all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a contingent ruling. But if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response and then we can try to get through that. That would be great.
And with the court, is the court asking for a copy of each of the statements? Because we can provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7, lines, whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then of course, if in court, I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary? Anybody? Does everybody have Mr. Zachary's statements?
Yes.
Okay.
That's fine. All right, I'll take the hit here.
MG Law, I like your opinion here. MG Law says, it could be that the judge is working on an opinion on mistrial that just isn't ready yet. So instead of having dead time while it's being drafted, she's moving forward with other issues. That's a possibility. Because there are a lot of motions for mistrial. And even though she denies them in court, she might want to write opinion on it.
They do keep sending you up here to be the one.
That's okay. I'll take it. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So We have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy
But y'all
has,
are all old like me and you like paper.
and because we have our notes on the paper too. And so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today. So
Yeah.
I didn't bring the transcripts with all my
Yeah,
notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but,
Understood.
okay, yeah, I hear you, you're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of
Okay.
talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and other witnesses that you're going to be getting to soon?
We have been, not entirely winnowed, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses,
I mean, Mr. Zachary is a witness, right?
but I don't believe that we have any jail calls from Quindary Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls for Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So portions we think we want to use, and then they can say, only look at those. Here are the objections we have.
Yes, I can do that. We have not broken it apart.
Okay.
Statement scientific.
Okay.
As I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just sort of.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What we can do as a prosecution team, over the next, however amount of time the court wishes to allow us, is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can.
But you only, Ms. Love, you only identified pre-trial of 3 statements in total by co-conspirators. And now you want 3 statements from 1? Seriously, what's going on? Oh, well, I know what's going on. Ms. Love is still used to Judge Glanville's rulings, who allowed everything in with the absolute bonkers argument from Ms. Love.
And that it will be coming up in the next batch of 30 witnesses. So we can identify, just to the court and the defense, those people, and begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some of them.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that.
Yes.
Yes,
Yeah, I said it, so
you did say it.
You know, I never know. But I overshot.
You might have overshot. All right. Well, hey, if you can even do it for 1, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything right now?
It's not anything. It's not anything we can go forward with, but Judge Glanville had given me, on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801 D2E issues, co-conspirator statements
Right.
issues. The court indicated that, well, it required the state to provide to the defense all of the 801 D2E statements that the state contended it would seek to admit
Okay.
during the course of the trial.
Okay.
That notice was filed on or about by the state on or about, excuse me, November 3rd
Okay.
of last
23.
year,
Okay.
obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same. They only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out a year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay. Understood.
So I want to get that on the record.
Right.
And finally, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever
Right.
that I want to re-allege and reaffirm.
And Mr. Nichols is charged with count one, the gang count.
Yes, that's correct.
Okay. Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that I know that all 6 of the defendants here are charged in count one, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, other than the RICO count, this doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you with that, whether you ultimately do that or not.
Yeah, I don't know. I'll hear from both sides. But
yeah, it's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right, so we'll get you that
Okay.
as soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. But does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice.
Because Judge Glanville promised he would get it in for us, but I don't think she will say that.
2022.
2022?
We provided 2 801 D2E notices.
Okay, so is one of them November 3rd of 2023?
Yes.
Okay.
Yes.
And then you're saying there's another one?
Yes, that's November. That was filed on November 30th of 2022.
Okay. And
Before? Hold on here. Well, the charge was in, and they said they were ready for trial end of November, early December 2022. I don't remember this one.
give me a second, Laura.
Studuzo no, sorry, Doquini? Sorry for butchering that. Thank you for being here. Thank you for giving the thumbs up and everything. Thank you. True story. Nick, can you please give your expert analysis on what this judge is doing? Are they pressuring her to keep the case going, or is she just attention seeking? At this point in time, I don't think she was thrown into this case, and it seems like she didn't have a reason to recuse herself. So I don't think she is attention seeking. And from what I've heard about her, this is how she run her trials. On point. If you want to have anything done, in proper time before anything goes down. And as she said in this trial, why are we doing this in the middle of the trial? In the middle of testimony. This should have been hashed out. So I don't think she is there for attention seeking. So far, she is conducting herself, despite I don't agree with her denying a few of the motion to mistrial. She's eons better than Judge Glanville. Eons. And since how the case, I mean, the case from the prosecution is garbage. It's rumors. It's gossip. With proper rulings going forward, if the trial goes forward, it will be interesting.
Thank you, Judge. In the 2022 notice, we stated that the state will establish the ongoing conspiracy of the YSL Criminal Street Gang Act trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial.
Yeah, you had all this before. I mean, now we are going back to things they had during the grand jury thingy. So how, if they haven't put it up in a motion, then off you fuck. This is not an answer.
Or in the presence of a defendant currently on trial, that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice? Okay. Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide.
Sorry, when you say in this particular notice, which notice?
The November 6th, 2023 notice.
Okay. November 6th. November 3rd?
He said it wrong.
It's filed. November, okay. You provided notice of 3 different statements.
Right. 3 specific ones.
Okay. Right?
Yes.
All right. So my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are. Just one moment.
All right.
Caught Miss Love by surprise again by actually asking her, have you done your damn job, counsel? And we still haven't, because she's used to just him. She fondles his balls for a few minutes, and he approves of
And so that
everything.
we are clear, because there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right. I have yet to find the notice that y'all are talking about.
The November 6th one? We can send it to the
Yes,
court.
there are a lot of filings
We can
in
send
this
it to the court.
case, but Ms. Persefield has saved it for me somewhere, but there are already a lot of things in our file also.
We'll
So,
send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it?
What?
Just emailing it to me because I need lots of assistance. Thank you, Laura.
What a faster clock. And this is all on the prosecution. This judge, and I hope she doesn't blame the defense for this, because everything that is wrong with this trial is because of the prosecution. They continue to fork things over against the defense. Late evidence. Changing names of files they want to present so that the defense doesn't know what they're talking about. It is everything is on the prosecution.
Judge to tell, was there an order at some point or a direction from the judge to tell the defense which statements you believed to be co-conspirator statements that led to this supplement?
Yes.
Yes, okay.
I'm looking for.
I don't, I mean, if there was, that's all I need to know. So yes, so, okay, now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included as part of the jail calls and the wiretap.
Okay, so they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement, we intend to use it.
Yes.
Okay, well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands
Yeah.
of jail calls involving dozens of people.
Yeah.
There are about 3,000.
I think you've said enough. I understand. Then provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know how it's supposed to not be trial by ambush anymore? It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but
They are.
at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery. Here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay?
Should have been. If there is an order that by this date, this will be provided, everything else is out. Should be out, but it seems like the judge is giving the prosecution one more chance.
And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator. Or not in fact, that'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now?
Yeah, cool. 1 second, I'm reviewing.
She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
And so that the court knows what I'm doing, I overheated. And so I had to.
By which you mean your laptop overheated?
I do mean my laptop. And I was.
Because I've told y'all not to overheat anymore.
So that's what's
Okay.
happening.
You have two co-counselors beside you with functioning computers.
Your Honor,
Yes, sir.
while she's waiting for that.
Sure.
Could I just briefly address a side issue?
Sure.
When we met for the status conference, I
Yes.
believe Mr. Harvey asked you if you would support us when other judges
Yes,
try to
I
drag us
recall
in.
that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, "Oh, I'd like Mr. Harvey for trial." And I said, "No, you can't have him." So
Thank you so much.
Yeah,
Your Honor.
mhm.
But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that.
Mhm.
So you were referencing that week last week where we were out and why we weren't working to prepare
Right,
for this.
right.
I was being called into court all over the state of Georgia.
Sure, I
just because,
imagine.
and maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation
Yeah.
to do for this week.
Uh-huh.
But unfortunately, I was hauled over all over the state.
right.
I'm
And,
sure
and we didn't really talk about that.
Yeah, are you going to cover us for that as well so that we
So-
can work on this trial during those breaks?
Because, I mean, we may just have to decide that on a break by break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, why don't we take that up kind of as we need to?
Okay.
That is really interesting. Remember, I've said throughout my coverage of this case that this trial in this courtroom, instead of this trial, they could have handled between 4 and 8 cases, misdemeanors and stuff per day. What I didn't think about, what I forgot about is the other cases these lawyers have that they can't go forward with because of this trial. There are so many victims in Fulton County that will not get their day in court because of this trial alone. And hold on here. It's Mr. Jingles. Hello, Mr. Jingles. Hello. You want to say hello to the audience? Look how happy he is. Look at this happy cat. Look at this happy cat. Hey. Yeah, that's Mr. Jingles. He's our mascot. We are all, if you who doesn't know, we are all part of Mr. Jingles Viking Thug Gang.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or take Friday mornings for motions and Friday afternoons off, or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for just myself.
I mean, let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer.
Okay, thank you.
All right. How long are you going to need? 2 minutes, 10 minutes, 1 minute? Okay.
Miss Love has even opened her mouth in less than 1 minute.
We're going to, Your Honor, we're going to allow Mr. Atkins to stand up and give to the court the calls that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
One of the wiretaps.
That took suspiciously a short amount of time, which tells me they have identified this a long time ago, and they have chosen deliberately to not share it with the defense until the very last minute, because Judge Glanville allowed it. Judge Whitaker will not, and there is a possibility that once she gets those statements, she says, well, this is, thank you, not allowed, because time. I don't know. We can always hope.
One of the wiretaps.
And Your Honor, this wiretap is a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of getting, I wanted for the defense to know where this
Yes.
specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page
Okay.
on that document. So
Right.
that's how I'm going to reference it for all parties
Okay.
to speak off the same sheet of music.
Okay. Give me a ballpark before you.
6,000 pages for this witness alone, or for that witness, not Woody, another witness. 6,000 pages, and that is all the defense have had to go by when the witness is on the stand, and all of a sudden, prior inconsistent statement, we want to play all of this, or some of it, and not giving the defense a proper chance to go in for a motion in limine.
You do that of how many there are.
Yes, Your Honor. Let me count these up.
Ballpark. 5, 20, 100.
More, they will be closer to 50 to 100.
Okay. So instead of standing there and reading them all, do you have them in writing?
I do. With what I can do is take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a document that has the date, time, reference number.
I would
and
think that would be
PDF
easier
page.
for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with
Okay.
is Demekion Garlington, who is a
Okay.
severed co-defendant.
Right. Okay.
And I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay.
For this particular portion.
Okay. All right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think.
Yeah, I have them all, sure. They went from 3 statements to up to 100. And as Gwendolyn says, this should have been provided a long time ago. This should have been handed to them before the start of this trial, in good timing, in order for them to litigate every single one of them before the jury was even sworn in. Now they will be again handed in their lap. Well, you have to do this. At what point? I mean, they are, if the judge allows this trial to continue, you have everything about Mr. Woody, Mr. Copeland. How are they supposed to do all of that? Remember, the prosecution's team is not just these 5 or these 3 on the bench and the 2 sitting behind them. It's the entirety of the DA's office with over 100 employees paid by the taxpayers. It's not fair.
I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator. You, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who
is-
also, he has pled guilty, but he was one of
Okay.
the 28 indicted defendants in this.
So you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor.
Okay.
Yes, Your
All
Honor.
right, Sumlin. And there are, you can do the same for him.
Correct.
Okay,
And he
perfect.
has less, it's hard for me.
That makes it a lot easier because remember, in the plea agreements, the witnesses are not allowed to say anything that points to the defendant's innocence. Yes, I went through, I mean, this was a long time ago. Hey, Corn Pope, yeah, you got to catch a live, yay! Yeah, so this is, they have people with plea deals that they may or may not have been coerced into for very, very light sentencings. And all they need to do is confirm what the prosecution says, because they more or less aren't allowed to tell the truth, unless they are Woody who doesn't care. N.Starow, wasn't there an 8 gig searchable drive that the state was supposed to give the defense in the beginning? Whatever it was, the state didn't get it done. Oh, that was in the beginning. It was 1.8 terabyte searchable drive. Then they suggested Dropbox. That was turned down immediately because if they use Dropbox, a shared Dropbox, then the prosecution can look at what are they searching for, and the defense didn't want that. Then it was 2 4 terabyte hard drives. I don't remember what it came down to.
The ballpark.
That's fine. I just was like, if it's 2, you can read them out. But if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay. All right. So that is 2 further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay.
That's a part of the 5,
Jail calls.
about a part, portion of the 5 jail calls.
All right. Hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in? Okay, that was part of the notice, so that one's good.
I don't think it's a part of the notice, but
They don't think that was part of the notice, but they're willing for y'all to say that's good.
but there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and all right, well, y'all have already been litigating that, so I'm going to call that one good in terms of notice. Whom else? Notice. All right, question. So I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay.
Yes.
Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right. All right. that I know. Can you provide to this judge whatever that supplement was so that I know?
Yes.
Thank you.
While they're not talking, hit the thumbs up.
Do y'all,
I just
deputies, you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do y'all actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
This is a quick question.
Yep.
I can't, I'm having a hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to, I can't find that.
Okay,
I'll look for that. I'll look for that.
During lunch.
I reference where it said that you can't use.
Okay.
matter of-
that'll be great.
Okay.
Thank you. All right, we're in recess. Let's say till 1:20 since we've already eaten up like 5 minutes.
muted again. Finally, we can go back to Doug Weinstein's Exhibit A. We have roughly half an hour before the court starts again. Maybe 25 minutes. This is the rough transcript. This is not the complete transcript, to my knowledge. "2:45 p.m. on that Friday, the 7th of June. Ms. Love, the reason that I specifically wanted to talk to you is that I have a concern about the representation being made of the representation of Mr. Copeland." Oh, really? Going back to this, ADA Hilton contacted Copeland directly, knowing that the last time they had contact, he was represented by Mr. I want to say Milton, sorry, Melinek. Remember that when we read through this. Because what she should have done is to contact Mr. Melinek. Are you representing Mr. Copeland? Yes or no? She didn't bother to do that. She contacted Copeland directly. She continues to say, "I'm concerned and I'm sort of not. I wanted to just bring it to the court's attention. Mr. Melinek has not conveyed to either Ms. Hilton, myself, or any member of the state that any legitimate concern that he has regarding Kenneth Copeland testifying." That is a lie. That is a lie. Complete fabrication. Mr. Melnick specifically said in email conversation, Melnick, thank you, specifically said in email conversation that he was extremely concerned regarding Kenneth Copeland's testifying. She continues to say, "What we have seen is physical interactions with persons beyond, beside Mr. Copeland, that would indicate that Mr. Copeland is not Mr. Melnick's primary priority." Here it is, Ms. Love, indicating that Mr. Melnick is violating everything he stands for as an attorney. Every oath he ever taken, the barcode, everything. This is sickening what Ms. Love is indicating here. What we do know is that when the fact that he's willing and wanting to leave, number one. He left twice after the court ordered him to speak with his client. And it would seem his actions convey that it's not Mr. Copeland's best interest that is his priority. Everything here should have been said in front of Mr. Melnick, so he had the opportunity to reply. this is, in my opinion, based on everything we read about the rules regarding ex parte meeting, already here, Judge Glanville should have said, we need to stop here because you're making statements about Mr. Melnick. He needs to be here to reply to it or in open court. And we already know Judge Glanville wanted to keep all of this a secret until after the trial concluded. Ms. Hilton was out speaking with Mr. Copeland at Mr. Copeland's request at the time that I announced that Ms. Hilton was calling Mr. Copeland. Why was she speaking to Mr. Copeland without his attorney present? At all. At this point in time, they know Melnick is representing Copeland. What the? And at Mr. Copeland's request, prove it. Show the recording, show the text, show the email. Ms. Hilton's word is worthless. What I did not know is that he was trying to tell you to give us a minute because Mr. Copeland was feverishly, and I will let her speak as to how that went down, feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that did not come from any of us. What? What a load of horse shit. The court, as in, the court here is Judge Glanville. The court. What was that, Miss Hilton? Miss Hilton. So let me just put the order of operation. I got up because Deputy Chief Long said, quote, he wants to talk to you. Come out right now. So now we need to hear from Deputy Long as a witness. Because that is his statement he made to, allegedly made to Miss Hilton. So when I went into the room, Melnick either came in or came outside. And what Mr. Copeland said, and I think he wanted to get some autonomy, quote, I want to talk to you, quote. He's like, quote, I've already talked to you, but I want to talk to her, end quote. And Mr. Melnick kept like blocking him being able to talk to me. So he was doing his job. So eventually I was like, well, clearly you want to talk to him, so I'll step out and you can come in, end quote. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. So by the time I got back in there and he started to talk, that is when everyone said, quote, come on, the judge is waiting, end quote. And that's why he stormed in angry. Miss Love, he being Mr. Copeland. This is... Mr. Copeland stormed in angrily in the judge's chambers? I don't think so. Miss Hilton. Because I think he was trying to convey to me some concerns he had. And so I was trying to have that conversation because Mr. Copeland and I have been having really good conversations since Friday. Like very good conversations. Why are you having conversations with the witness that you are about to call? Now, you can always have not instructing, but proffer, or here is how we want you to testify, not what you're going to testify about. I mean, yeah, so they are talking about Mr. Copeland and conversation with Miss Hilton. This alone makes Miss Hilton a witness. Just not even about the facts of the case, but just life experiences. Oh, really? So I think I was building a report with him such that he thought I lied to him. So I was trying to explain to him, Miss Love, and by that she means today, Miss Hilton, today about what was going to happen. Miss Love, because of what someone conveyed to him. This sounds like they are fishing for attorney-client privilege information. Now, Mr. Copeland can waive that right, but not if they are coercing him into it, in my opinion. Miss Hilton, we believe that something was being conveyed. What happened is, as Mr. Copeland was walking back into the courtroom, Mr. Melnick and Julie would have to, Miss Lancicott would have to confirm this, but he said, quote, they are going to hammer you, end quote. And that made me ask Miss Love, did you say something about hammering him, end quote? And I don't know who. Miss Love, nobody did. I don't trust them. Now, him, and if they overheard Mr. Melnick talking to his client, or were they eavesdropping on attorney-client privilege information? Did they, Mr. Melnick and Mr. Copeland, believe they were out of earshot? Was Miss Love or Miss Hilton eavesdropping? We are on line 15 here. The court, it doesn't make sense. You would say that to him. Miss Love, we never said that. The court, but anyways, okay. Miss Hilton, so whatever that communication was, that's when he stormed in and got angry, and the result I got was what he gave when we started. So at this point, I'm very concerned. Miss Love, he, meaning Mr. Copeland, stormed in and got angry. Miss Hilton, the timing of everything is very ironic. We laid it out on the record earlier about what happened, and I don't believe that Mr. Copeland's best interest is being served at this moment, given that this is so improper. If you believe Mr. Melnick isn't doing what is proper for his client, you need to bring that in as a motion in open fucking court, not in a secret meeting. This is so casual. This conversation is so casual between Love, Hilton, and the judge. I'm very convinced now that they are having out of court conversation with the judge. The three of them. I'm very convinced of that. And that there are conversations that will never see the face, that will never see the light of day, because it was never with a court reporter. Mr. Melnick was willing to take a vacation and let him languish in jail. Oh, fuck you. Miss Hilton, you knew the timing of Mr. Melnick's vacation. You have known that for months. And you despicable human being. And that is not, we have communicated that he never wanted Mr. Copeland to go to jail. We don't want him in custody. We don't want any of that to occur. And so Ms. Love continues, and Mr. Melnick has not spoken. He has not relayed. What we did get during the break was an email from Mr. Melnick. I don't know if he had to have been blind copying someone else. The only two people I could see on the email were Ms. Hilton and myself, but he referred to me in the third person and said, these are the communication between myself and Ms. Love. There is no evidence of an email like this. None. Zero. And until Ms. Love presents that specific email with that specific wording, I'm calling her out as a lying liar who lies. So I asked Mr. Melnick, whose interest are you concerned about? Your clients or Mr. Steele's and Mr. Shark's? Because prior to, and this is not the first time Mr. Copeland has said, quote, he doesn't represent me, end quote. We don't know that. We only have Miss Hilton's word for it, and we know how unethical Miss Hilton is. This is not the first time Mr. Melnick has, and let me be real clear, when he spoke of what was happening before, him representing Mr. Copeland and he told me that he didn't represent Mr. Copeland. She's lying. that unless she has it on a recording, unless she has it on paper or email or text, I think she's lying. Yeah, Heather Marshall says here, Steele already said in court that the state misrepresented the emails. I hope Mr. Melnick brings the actual emails. Here's the caveat. If emails, that will be hard, because if he can't bring emails between him and Woody, but him emailing Ms. Love and CCing some of the defense attorneys, that he can bring in. But yeah, I believe this is a lie. The court, Mr. Melnick told you? Ms. Love, yes, Mr. Melnick told me previously that he wasn't representing him. Remember, didn't they? Yeah, this is a lie, I believe. The court, you would not speak to an unrepresented party. I mean, I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact that lawyer. Ms. Hilton, or Mr. Copeland would have said, because I don't know as a witness, because he's not charged, if we would have had to, Mr. Love, right, because he's not charged. The court, I don't think you have to, because there's no pending charges. But if he told you, quote, I got a lawyer, I don't want to talk to you, Ms. Love says, we would have left. No, we already know that Ms. Hilton contacted Mr. Copeland, despite knowing, again, I've said this before, I will say it again. She contacted Mr. Copeland knowing that the last contact she had with Mr. Copeland, Mr. Melnick was representing him. That makes her required to talk to Melnick first. The court, because people counsel that they have under retainer or something else, or they say, quote, hey, I got a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking to you unless my lawyer is present, end quote. Ms. Hilton, we have done that with a number of our witnesses here, so this would have been no different. Ms. Love, exactly, and we would have, I'm sorry, I don't mean to cut you off. Ms. Hilton, no, go ahead, that was it. Ms. Love, we actually communicate, especially when either they are incarcerated or subject to having their sentence revoked as a result of the testimony because they pled guilty here. We only reach out to them through their attorney because we want their attorney to speak to them, and for that to be, because that's the best way, in our opinion, to get a report that elicits truthful testimony. Bull crap. Bull crap. Bull crap. We know they contacted Mr. Copeland directly, not through Mr. Melnick. We already know that. It's on the record. She continues, so in this particular instance, there was not, that number one, there was not that communication made by Mr. Copeland that there was ever a need for that. And two, there was not a need for us to be concerned about it because it doesn't have charges. Ms. Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking to him about, the statute of limitations has run. He didn't do the murder. We know that. How do you know that? He was never investigated as the possible murderer. Yet, he has strangely really good information and motive to pin it on somebody else. MG Law says, doesn't matter if he's charged or not. If he has counsel, then she can contact him directly without prior authorization from that attorney. Exactly. She continues, I mean, so I don't want to get into the facts of anything. What I'm trying to get at is the fact that Mr. Copeland, I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interest of our witness. Ms. Love, you have absolutely zero right to represent interest of a witness. 0. Absolute 0. She continues, I believe that in conveying to the court that Miss Bumpers is going to stand in his stead. Miss Bumpers has been, she had to be, she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. Miss Hilton, no, she hugged Diamante Kendrick. Miss Love, I'm sorry. In fact, she hugged Diamante Kendrick and hugged Mr. Williams, and that's how Captain Kendall saw her. And Captain Kendall had her taken out. I don't know if that's happened or not. I have no idea. But since we caught numerous lies already, I don't take it out of the possibility they are lying about Miss Bumpers as well. Miss Love, she expressed dismay and concern in challenging her right to go interact in that manner with the defendants. So our concern is that it is not Mr. Copeland's best interests that are being represented. File a fucking motion. Make a bar complaint. Don't do the whisper game with a judge in a secret ex parte meeting. And that not only is that the case with respect to Mr. Copeland, who we have no interest in prosecuting. Of course you haven't. He lies for you. Who we have no interest about. But there is a tampering of sorts going on in this person inserting himself where Mr. Copeland has been reaching out to speak to Miss Hilton, and that communication is being blocked by someone Mr. Copeland didn't reach out to. Now they are accusing Miss Bumpers for tampering. Folks, that is a crime. And if they can't substantiate that, that is defamation per se, possibly. You notice no one said Mr. Copeland called me. Doesn't have to. He never said, when we put on the record, when Miss Hilton said, quote, the way I understand it, Mr. Melnick reached out to Mr. Copeland, end quote. Because the first time we heard an assertion like, quote, oh, he's going to plead the fifth, end quote, is when Mr. Melnick sent an email to Miss Hilton and myself and had copied on it Mr. Steele and Mr. Short last night. Last night in this context is June 6th, before Mr. Copeland took the stand. Which means they knew he was going to plead the fifth. And that is why they ran to the judge Friday morning to get that immunity thingy. The court. Why would he have done that given Miss Hilton? And that's the state's concern. Miss Love, that's the point. The court. But here is the challenge. The challenge is you have privileged communications. And unless you got him being the client, disclosing to a third party that wouldn't be subject to the privilege. That is the only way you're going to. Now they are debating tactics in this ex parte meeting. This right here, the highlighted thing, is giving the prosecution an unfair advantage. Ms. Love, I don't disagree with that at all. But if Mr. Melnick, and the thing that got me the most is Mr. Melnick is not looking at Mr. Copeland saying, quote, you know, Mr. Copeland, I want you to stay out of jail and I will be here with you. You have absolutely zero right to make this argument. Zero. And if they ask me anything that touches upon something that you and I talked about, I will stand up and assert your right, end quote. He didn't do that. What he did was looked over at the two people and said, like, quote, I did what I could, end quote. Oh, this is shrugged his shoulders, held up the palm of his hands like this, and as to say, "I tried," end quote. That shoulder shrug never happened. We checked, me and Captain Williams, we looked at it. That never happened. Again, they are lying to Judge Glanville, making false assertions over and over and over again in this ex parte meeting. There is no reason he would be looking to the right to counsel for the defense like, quote, "I tried," end quote, after Mr. Copeland said he was going to testify. That doesn't make sense. This is so appalling. The court. Well, there's a lot of innuendo that they have asserted themselves. They, being some of the defense counsel, have inserted themselves in this particular process, and that's what... This sounds really close to a ruling or a finding a fact, which neither of the defense attorneys were present in order to defend themselves. This is highly improper. Highly improper. Ms. Love, my concern is Mr. Melnick's insertion of himself. The court. What are you asking me to do? What are you asking me to do? And what do you think that I can do? Why is he asking her that? Why is he asking for advice from her in a secret ex parte meeting? That is the exercise, that is the homework for tonight? Are you fucking kidding me? Miss Love is giving Judge Glanville homework. She continues, I wanted to let the court know that that is what we're looking into right now, because there is a remedy, because I have faith in our law. I love this thing. And I know there is a remedy because this can never have been the first time this happened. It has been addressed. I just have to find it. Oh, you harlot. But I didn't want to be looking for something and not let the court know what I'm looking for, so you are not, so that you are caught off guard when Monday morning or Saturday night or Saturday afternoon we find it and send it to you. Are you kidding me? This is so improper. How can Judge Whitaker look at the transcript and not throw this case out? The fuck? The court. Okay. Ms. Love, so thank you for allowing us to audience with the court. I just wanted to make certain that we did it properly and we have everything on the record. This is so not proper. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he talks about on the stand and any use of that. False on its face. He can be prosecuted. They cannot just... The only thing on federal level or local level, the only, because they use immunity, which is a weirder kind of immunity, they can still prosecute him. They just can't use the information he conveyed on the stand. They can still prosecute him if the crimes haven't the statute of limitation. And the thing is that we won't ask him that, but this is what he said. Y'all might not, but they might ask me about some things that I have asserted my right on, and that would be a question by question basis. What he's being influenced to do, we believe, by Mr. Melnick, and it's through Mr. Melnick because, as you saw, Kenneth Copeland said, quote, I will testify. Mr. Melnick, even after that said, he's asserting his fifth. I'm going to go talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Kenneth Copeland's freedom, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, quote, I am here with you. If there's something that I no will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail, end quote. Again, this is, no. Instead, you get Mr. Copeland, and you can see it through his body language. He gets there in court, and he's smiling as if making a show of being taken into custody after this. And the man don't want to be in jail. He said it. Didn't he say you don't want to be in jail? Miss Hilton, that's his biggest fear? No. Miss Love, that's his biggest fear, and now he's in jail after Mr. Melnick asserted himself in this process. Mr. Melnick is Copeland's lawyer. That is not inserting themselves. That is you trying to exclude Mr. Copeland's lawyer. So we have to figure it out. I'm not just laying it in your lap saying, go fix this. I'm just bringing this to the court's attention. This is a great concern. Miss Hilton, she is about to lose her mind because her biggest concern is that Mr. Melnick is actively harming a human being. And that's what she is maddest about. Oh, screw you. I'm mad because it is stopping our trial. And it's wrong. And that is not how the law is supposed to work. You, Miss Love, shouldn't be doing law at all. At all. So we have two big old grave concerns that we are working to remedy right now. Again, this is something that should have been argued with defense counsel, or at least Mr. Melnick present. The court. Okay, well, like I said, I think that you brought your concerns to me. You know, without more, I don't know what else I can kind of do in terms of that. My comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have to do with anything with you all's case. It really shouldn't. But I think it does in some way outside agitators. That too. And everybody else who think I'm trying to, who I think are trying to influence. That is absolutely happening. Miss Hilton, there's a lot going on. Miss Love, there's a presence. Yes, that is all I'll say. Now they are trying to avoid getting things on the record. The court, but I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. And like I said, since we now know he's going to potentially invoke, we'll see what his pleasure is and. Miss Love, just the idea of someone sitting in jail throughout this trial, but if that's what he's being counseled to do and that's what he does, that's just wrong. It's wrong because a member of the bar is, in my mind, creating that circumstance, you know. They are actually blaming Mr. Melnick for this. They are so mad they didn't get away with having circumvented Mr. Melnick. They are so mad they are blaming Mr. Melnick for all of this. This is narcissism on its face. They really don't believe they can do wrong. They believe themselves to be the epitome of judicial knowledge. And we know just by looking at this trial how absolutely fucked up their interpretation of law, justice, and due process is. She continues, he's going to do what the person he trusts to have his best interest at heart tells him to do. And that person, he doesn't have to tell us what he's concerned about and can just sit there. And when he sees the train coming, stand up and say stop, but he's got a vacation to go on, so he can't be there. Again, you knew this was scheduled, his vacation. You knew. And today, remember, or yesterday, they asked, can we please switch so that Miss Hilton won't be questioning Mr. Copeland because Miss Hilton is going on vacation? You absolute hypocrite. They continue. So Miss Bumpus is going to be here. Miss Bumpus, hugging Mr. Kendrick and Mr. Williams, is going to be here representing the interest of Kenneth Copeland, who is supposed to testify against Mr. Kendrick and Mr. Williams. GD asks, Nick, doesn't this appear that they have been doing this for years? Yes, it does. Yes, it does. That is where we are. That doesn't pass a smell test. You don't pass a smell test, Miss Love or Miss Hilton, because you reek of garbage and vomit and puss and everything. The reason why you don't see something passing the smell test is because your nose is too close to your mouth. The court, all right, okay, Miss Love, thank you. And that is the end of that rough transcript. These two secret ex parte meetings, folks. Shows corruption. And sadly, I'm not surprised, because if you've been here before, you know I've said this before. This is Bonnie Willis. And you all know she lied in church on a Martin Luther King sermon about her actions regarding Nathan Wade. She doesn't hesitate to lie, not even in church. It is, yeah. Shouldn't the court be back by now? 1:20 p.m. estimated. We are 10 minutes late. Why are we 10 minutes late? I don't know what to say. I do not know what to say. And it is 7:30 p.m. here, and they are late. I don't know what's going to happen. I haven't eaten since lunch, my time. I need to do an off-eye fuck. Okay, 1:30 presently. Well, that's now. I need to do an off-IF motion because I really need to eat. What I will do is I will do it like this and like this, because I really, really need food, because I'm so, yeah. MG Law talks about if this murder is dismissed with prejudice, then all of the other RICO charges which are tried to fall away. There are 2 murder charges in this, sadly. So even if this goes away, they still have the other one. But I think this particular, the Donovan Thomas one, is the strongest they have. But I need to get myself some food. I really do. And so I kind of want to play pause music or elevator music, but yeah, I can do that, at least on a low volume, so it doesn't impact. Okay, I will go eat now. You keep watching the screen.
afternoon. Hope everybody had a good lunch. What were we able to sort out with regard to other potential co-conspirator statements? Identifying those.
John, we have a list of potential ones.
Okay.
Sort of a broader universe. And I'd like to narrow them down before handing them over. Some of them we have reviewed and they have statements about drugs that we may not want to introduce. So there's a large volume of, for instance, calls that have certain commentary in them.
Okay. So you can identify the statements and you're saying that it may be less than the full statement and you can further narrow that, but you at least at this point have the person and their statements.
Yes.
Okay.
Up to a point, yes.
Okay. Up to what? You can go ahead and continue to explain.
So, and that's the way it is, with a number of the jail calls and the calls from the wiretaps that we have reviewed so
Okay.
far.
Okay.
We have, there are some that are left unreviewed, but the ones that we reviewed.
Okay. And for the ones that are left unreviewed, can you identify, here's the person and here's their universe of statements? We just can't tell you what portions yet? Do you understand what I'm asking?
I think I do, and I don't think that you can. When you said, if you could just clarify.
Okay, so why don't you do what you can right now, and then I'll ask you the rest of it. So as to what you have prepared, let's go ahead and share that.
Okay, so this is much in the way that Mr. Atkins was a list of
Right.
54 calls.
Okay.
It's similar. It contains
You don't have to count the number. You can just go ahead and give them the notice.
Okay.
Is it something that you have like a written list?
So yes, it's an internal list of notes
Okay.
and calls that are identified.
Okay.
So what I can do is provide to them just the calls that are identified.
Okay. So do you want to do that in writing?
Yes.
Okay. So do you want, could you at least in court identify the witnesses?
So So when you say the witnesses, you mean who we're going to be introducing through?
No, that's not what I mean. I mean, who is the alleged co-conspirator whose statement you think you're going to use? And if you have the witness you're going to use, I get it in through, that's great too. But we're looking for co-conspirator statements. So we need to know the ID of the co-conspirator. Okay.
So mainly the ones from the Garlington wiretap are the ones that are identified in the majority. That's the ones that we have the majority of. The remaining jail calls that we've identified, they are jail calls of Diamante Kendrick, Martinez Arnold, Shannon Jackson, all of whom are actual defendants who either are currently in trial or who have pled, and Marvius Nichols.
I'm sorry, I didn't, number one, I didn't hear that. Sorry, I just couldn't
Okay.
hear it. And number, my original objection just was.
Is your mic on?
My original objection was too little, too late. In other words,
I understand.
okay.
I'm just
so-
trying to sort out what there even potentially is at this point, and then, which is harder than it should be. And then I will hear why it hasn't been shared before and why it should now be permitted regardless.
Thank you.
Thank you. So can you say those four people again louder so Mr. Harvey can hear?
Yes, Your Honor. The jail calls, the jail calls of the persons that I have in my hand that we're reviewing are jail calls of people who are currently on trial or who were on trial and entered a plea.
Okay.
So I don't think that that counts for what Mr. Harvey is talking about in terms of co-conspirator statements. In other words, for instance, I have Mr. Kendricks, Mr. Stillwell, Mr. Nichols, jail calls that we had under review by the team who was working on that. And that we've identified calls from that we intended to use.
If I may respond to that, if it's Mr. Nichols' phone calls, the kid has been in jail for a couple of years, number one. Number two, those are his statements. I'm entitled to those under the discovery statute. And if they're just looking at them now, 2 years later, you should, without any question at all, exclude those. I mean, this is,
Okay.
come on, 2 years later.
It is my understanding that everything that my understanding based on your representation to me earlier today in court, that everything that you intend to use as a co-conspirator statement has been provided to the defense in discovery. Is that correct?
Correct.
Okay. And so what we're doing now is y'all asked that it be identified which are going to be co-conspirator statements. So it's not that you don't have it, it's that it has yet to be identified as a potential co-conspirator statement. So with regard to your objection about not having it, you have it, it sounds like. Now, if it's a statement of one of the defendants on trial right now, but it is going to be used against another one of the defendants on trial right now, it is, right?
Yes.
Then it is a co-conspirator statement. So, Mr. Nichols, Mr. Kendrick, Mr. Stillwell, you also said Mr. Arnold and Mr. Jackson. And did you say that both of those people have pled?
Mr. Arnold has pled.
Okay.
And I said Jackson, but Jackson is Stillwell. So that was
okay.
Statement.
All right. So the only person you've identified other than the three that are on trial right now is Mr. Arnold who pled.
Right. And there's also Nichols, Kendrick, Stillwell. And I have a jail call from Quindarius Zachary.
Okay.
We've identified.
That you've identified only now, not previously. So don't tell me that the three that were already identified, they don't have an issue with in terms of it. Late notice, yes. So was Zachary one of the people that had been identified in that November 2023 notice? Because the notice I have says person A, person B, so I don't know who they are.
Right. So Not the jail call, the statements that he has made, but not the jail call. So the name, I believe Zachary is either A, B, or C. I have to look at our
Okay,
notes.
doesn't matter who. Yes, he was identified as one of the people whose co-conspirator statements were you intended to introduce, but the jail call wasn't identified within there.
That is my.
Okay. Is the jail call subsequent to the time that you provided the notice?
No, the jail call date is 2015. It's in 2015.
Okay, so is there a reason you didn't include the jail call in the notice that you provided?
When we were preparing the notice, our understanding of the need to extract jail calls that.
Oh, she's so mumbling. I will be. I found a pack of animal crackers. Better than nothing. Admit it, Miss Love. You screwed up. You didn't put them in your notice. That should mean bye-bye. Should. We don't know yet.
Contain this information or wiretap calls that contain this information and identify them was separate from our obligations regarding generally what co-conspirators say.
Okay. Can somebody provide me either the order, oral or written, or the directive that the court gave to the state so that I can figure out whether that was a reasonable interpretation?
And we're going to
Okay.
get that for you. And at the time that we were under the obligation to present the co-conspirator statements, we were still, and the court was aware, we were still listening to, because there was an ongoing.
You twat. You told this court you were ready for trial in early December 2022. We are now July 31st of 2024. And you claim you still haven't actually listened to the out.
Commentary about the jail calls and the number of them and identifying them. So we were still listening to.
Okay. So at some point, presumably, you completed your listening. I mean, I know they're still ongoing, so I'm not talking about a jail call somebody did last night. But
Even
okay.
all of the ones.
Do you understand? I'm sorry to interrupt you, but let me back up and ask a different question instead. Did you understand that you had a continuing obligation to notify of co-conspirator statements, even if it didn't include jail calls and wiretaps?
Yes.
Okay. And with regard to whether there was some other understanding about jail calls and wiretaps, I'll sort that out later. Let's, at this point, are there other people who you think are co-conspirators, who you think you have
No, because she makes it up when she needs to. The defense objects, who is this person? Ms. Lowe stands up, oh, he is an unindicted co-conspirator. She makes things up and Judge Glanville went along with it.
conspirator statements for that you are potentially going to want to admit in this trial. And let me direct your attention to, because this might help you a little bit, you a couple of days ago provided at the court's request to the court, and I assume to opposing counsel, a kind of modified list of witnesses still to go.
Mhm.
All right. And you have at least a broad outline of evidence you expect with those witnesses. And some of these people you have actually identified specifically as co-conspirators. So, I mean, can we go through that and at least with regard to those people, see whether, yes, in fact, there is potentially such a
Yes.
piece of evidence? All right. So if everybody wants to follow along and pull out your state's witness list, the first one that I notice is number 3, Antonio Sledge, who you say is a co-conspirator, and then on your evidence you have listed a defendant interview and a jail call.
Right.
Could that potentially be?
Yes.
Okay.
Yes.
So we can add Sledge to the list. Then Zachary, you mentioned, so he's already on our list. Now, some of these I just don't know, but there are a lot of them that have interview or something like that over to the side. I mean, somebody like number 7, Kenya Morton. I don't think she's a co-conspirator, but okay. And then Arnold, who's number 27, you mentioned. How about number 35, Wooney Lee, who you have labeled as a co-conspirator?
He is.
Okay, and are there potentially co-conspirator statements from him?
Thank you. Thank you. Sticking with the whole.
So unless what we have of Winnie Lee consists of social media evidence. So arguably, if that could be considered co-conspirator statement.
Say better to say yes, I think so, and it not be than the other way around at this point. I think it was 35. 33. It says 35. Oh, no, it says 35 on mine because I got what, today maybe? Or yesterday afternoon, an amended witness list that adds a few people.
Oh, for
And
fuck's
Your Honor-
sake. Yesterday, they said, oh, we need these 105 more witnesses. And the judge says, yeah, that's still a lot of people. And what does the prosecution do? They add on more people again. For fuck's sake. At what point, Judge Whitaker, is enough enough? At what point is enough enough?
For the record, it added 2 custodian records for
Okay.
Sprint and T-Mobile.
Okay. So anyway, Wooney Lee, either number 33 or 35. How about, and you mentioned Sumlin earlier this morning, and Sumlin y'all already had notice of from November of 2023. So Sumlin's okay. I mean, that may be it in terms of, in my review over lunch, what I noticed to be pretty obvious ones. Are there other ones?
As we're reviewing the reports.
Auntie M says here, and this is interesting, if the judges letting the prosecution hang themselves. Yeah, but the risk is that they might by accident find something. That's the... ahead. You missed a lot, Dave. That the prosecution was asked in November 6th of 2023 to provide notice of co-conspirator statements. They gave notice of 3 co-conspirator statements. Now they claim for one of these people alone, they have up to 100 statements.
On trial. And Your Honor, I think I took it for granted, but all of the 6 co-defendants currently on trial, their statements, their social media, and the jail calls that they have, that we have of them,
Okay.
would be
All right.
considered co-conspirator.
All right, and I think that with regard to the 6 co-defendants on trial, it is, I mean, pretty obvious considering that there's a RICO count as well, that the state considers those people to be co-conspirators of each other. It still might be helpful to identify the statements, but with regard to deficiency of notice as to those people, I'm going to say that's okay, that's kind of within the context of there being a RICO count against them all. That notifies the defense that at least you think they're all co-conspirators. So if you can identify the statements as well. So that leaves, I guess, so does that mean that there are no others other than the ones we've run through just now?
I want to say that is accurate. I want to be accurate before I say that is accurate.
So while she's making sure she's being accurate now, somebody else can tell me, so on the notice that is from November 2023, the 2 people who are they? Zachary and Sumlin, the people that are identified as like person A and person B? Everybody seems to know except me at this point. I mean, y'all know at this point. So how about somebody on the defense side tell me? And you don't even have to say who's who, just. Oh, okay. Mr. Weinstein, you're looking at me like, I know, but.
Looking at you like, this seems like a job for Max Sharp.
Apparently it is, because here he comes.
I'm looking at, am I correct that you're asking about this notice of the 3?
Yeah, there's a like, I don't know what it says, witness A and witness B, or person A and person B. And then y'all said, or she said, there was a supplement that actually identified who those people were. So,
Your Honor, witness A was Mr. Copeland, and in that notice, we talk about the statements that Mr. Garlington made to Mr. Copeland. Witness B was Quindarius Zachary.
okay. All right.
And he's talking about statements that were made by
All right.
Defendant Stillwell and Defendant Kendrick.
Okay.
And
Yes.
I agree with 1 and 2. 3, I'm not sure has played out in actual testimony.
Okay. Do y'all know who 3 is?
So, I think it says Donovan Thomas Sr. to his, but that was a co-conspirator.
What? Did Miss Hilton just now said they regarded Donovan Thomas Sr. as a co-conspirator? Let me play that back.
Out in actual testimony.
Okay. Do y'all know who 3 is?
So, I think
Yes, it says Donovan Thomas Sr. to his, but that was a co-conspirator.
How is Donovan Thomas Sr. a co-conspirator? And how was that not disclosed before he testified? I'm raising my audio a bit more. How is it that we now find out months? Mr. Thomas was on the stand about 2 weeks before Copeland took the stand. And now we find out the state regarded him as a co-conspirator to the YSL gang?
There's only an A and a B that are like not identified people, right? Okay. Okay.
But 3 is not a co-conspirator statement. Correct.
Okay.
So there's only 2 co-conspirator statements. Alleged co-conspirator statements.
Okay. All right. So with regard then to,
Yeah, they are all, regardless, it's all late. They should have been disclosed
Damone Blaylock, Your Honor.
before the trial.
There's statements that are made, well, there's social media that we have identified. Damone Blaylock is a defendant in this case who's been severed.
okay.
He, social media from the incident listed on the indictment that he was already tried for with one of the other defendants currently on trial.
Okay. And Lee is also a severed co-defendant, right?
Lee, yes.
Okay. How about Sledge?
Sledge is a co-defendant that already pled guilty.
Okay. All right. Yes.
You might want to know Mr. Lee, Willie Lee, he resolved this case with Lee.
Okay. But I mean, he was at one point part of this indictment,
He was
the big indictment. Okay. All right. So then really for everybody that was a part of this indictment, everybody was charged under the RICO count, right?
Yes.
Okay. So it will come as no surprise that the state thinks they are co-conspirators because the state literally alleged that in the indictment.
But they still haven't given notice on what the statements actually were. That's the issue here.
So at this point, there is an objection that they don't have notification of what the statements are. And we are several months in. How quickly can you get to them the detail about what you think co-conspirator statements you intend to introduce?
No.
Go ahead.
Why? It shouldn't. Actions and consequences, Whitaker. Actions and consequences. They chose to not disclose, despite having months and months and months, and they chose not to. Action must have consequences.
Your Honor, not certain what amount of time the court
willing to allow us to identify anything not already identified or in the indictment. I don't know if a week exceeds what the court is willing to give. It's what we would ask to identify within the discovery already provided.
Right.
Identify specific statements that are.
I'm moving the mic closer and put it up to 200%. That's just, I can do more. Hold on it. What did you say?
Within the discovery already provided,
Right.
Identify specific statements that are there. We would ask for a week to identify that.
A week for something you have had in your possession for years. Years.
All right. Understanding, Mr. Harvey, your objection to delayed notice. I am going to overrule that objection right now to the admission of the evidence. We, of course.
They're not even now. This is.
Still need to know what the actual evidence is. And a part of the basis for me overruling that is that it appears that the whole trial has kind of been operating on a rolling basis with regard to the evidence. And there have been orders even that, hey, you know, every other Friday, let's talk about the evidence that's coming in for the next 2 weeks. And so if that's been the understanding, then
No,
so
no.
be it. But I want that to stop right now, which is why we are going through in what I consider to be painstaking detail, because this really should not be what the court is spending its time doing. This is what y'all ought to be doing on your own. But I want us to get on.
Judge Whitaker, just because Judge Glanville's misconduct throughout these proceedings was allowing garbage like this in, doesn't mean you have to.
On a track where the litigants know what is potentially coming in against them, less than here's the universe. And I want us to be efficient, but I don't want y'all, anybody, either side, having to try the case sort of, you know, blind, or practically blind.
Say that because you know it is wrong. And you also know that is how Judge Glanville conducted himself. That is clear grounds for mistrial with prejudice.
So now that I hope we all are getting a better understanding of how it ought to work moving forward, I am going to give y'all, because I've given y'all a lot of other tasks as well, 1 week until next Thursday to get all of that in detail, including anything in wiretaps, including anything in jail calls to the defense. Okay. You look like you want to say something, Mr. Steele. Okay.
I want to say thank you.
All right. You're welcome. Okay. So, what else can we get done today?
Yeah, just to address a matter that the court asked me about before lunch. The court had asked, when I represented that my understanding, if I'm not mistaken, was that the matter of disqualification of a judge was not competent evidence to be used in the trial. I think I said
Yes.
something akin to that.
Yeah, and you said you had some kind of law that
Yeah,
you could provide to us.
What
Yes.
what I referred to was Georgia Uniform Superior Court Rule 25.6, and my understanding of it.
Okay.
If it's different than the courts, then that's not unusual. But the last two lines of the rules say that if a motion to recuse is sustained, the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So the way that I understood that, and of course that rule is, cited in other cases, for instance, not for the proposition that the disqualification is not competent evidence. It's just cited in a block cite in Evans versus Williams, 341 Georgia App 226. But that's my understanding. If my understanding is not in line with what the court's understanding is, we would have other arguments against the idea that somehow the recusal of the former trial judge is competent evidence and in some way relevant to whether or not the defendants did or did not do what they are alleged to have done.
Well, it's not relevant evidence as to whether the defendants did or did not do what they're alleged to have done. It cannot in any way be evidence of that.
I was as to relevance. That was
Okay.
what I was saying.
All right. So relevance will be a separate issue from whether it is, and I can already anticipate the argument because I would make this argument. What you just read says any other case or proceedings. What does that mean for the case that it happens in? So I think we probably need a little bit more research.
And that is what I sought to do over the lunch hour, but I did not find any Georgia case law that elaborated on that. I didn't find any case law that elaborated on that. And so that was...
There is no other, probably very few case law in the United States, because not a single one of these cases where the judge was yeeted from the case survived to an appeals in order for it to have become case law. Every other case, when the judge is yeeted because of misconduct, it is a mistrial. That is my interpretation of why they can't find case law.
All right.
That was where I stood.
Okay. Well, thanks for letting us know what it is you were referencing, and I'm not sure if it actually answers our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that. Either competency-wise or relevance-wise, although I think I pretty fully understand the defense argument on it. But, okay, thank you. So...
For you who didn't know, I went on Cat Not Williams' stream after my stream yesterday, and I continued throughout, even though I should have gone to bed much earlier. Today, unless something extreme happens, I'm making a hard cut off at 9:30 my time, which is in an hour and 15 minutes. Which should be around 3:30 p.m. Eastern Standard Time. Just so you know, and then we will go over what we missed tomorrow morning, your time.
I know we're not quite ready on the Copeland evidence. I think we have sent out some of the transcripts we've got already. So we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of?
Yeah, right, you're ready on the Zachary.
The statements.
Yeah.
I'm a little confused. It's not even showing that I have a message, but okay. So that's a problem. Yes.
So regarding Zachary, when we're talking about the co-conspirator statements,
If the court staff could get the fuck out and not interrupting the proceedings.
we've been talking about Mr. Quindarius Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements.
Right.
And we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught Nut down bad. And then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught Nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Judge,
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that two defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay,
and
so the answer is no, it's not just those two.
right. It's the whole state.
No, it's not just those two.
Right. Well,
And so,
my understanding is the state is saying, and I don't know if this is true or not, but the state is saying at this point, to the extent that they know, that Mr. Zachary's taking the stand. So I mean, that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking the stand. I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those two statements,
okay.
which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance, but I don't know. I can't answer the other statements that I have not been identified specifically.
The statements that the statements that Quindarius Zachary gave to the police, I'm certain
You have to
everyone is aware within those statements contains statements made by other people within YSL. When he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL. He may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quindarius Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete.
This is just word salad at this point. You need to identify the specific statements. You can't say, oh, it's all over the interview. That's not specifying. That is a generalization. That is not what the court asked you, Ms. Love. Please, Judge Whitaker, put a stop to this.
Bit of information that they have noticed that we are using that.
All right, so I think I hear you saying that with regard to anybody named with at least one count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
That,
If it is contained within an interview that we have given to them,
Okay.
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement.
Not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, we're on trial. So.
Right, but they're co-indictees.
Yes.
So I was talking about people other than the co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To the extent that we have given them that interview, yes.
All right, and so are you seeking to say, and maybe this is where Mr. Shard is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements?
No.
Or are you going to break it down further within the next week?
We will break it down further, but there are only, I think, the people who've pled, and Quindarius Zachary and Kenneth Copeland, who were not indicted, that fall up under that umbrella.
Narrowing down.
Does that answer at all your question?
Can I explain how it really doesn't, and it's kind of to move from the theoretical,
Yep.
the theoretical to the reality.
Yep.
The reality is these statements. For instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in the room with Mr. Zachary and his attorney. The district attorney, you're really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house.
Mm-hmm.
And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of it. The shooting of the convenience store on Cleveland, I'm just making this up,
Yeah,
Cleveland
sure.
Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding, And there's no real, these aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him,
Right. So
and
you
everything
need
else.
to know in
Right.
more detail.
Who
Is
the
the
sources-
state, is the state planning to use, I think Shannon did that.
Right.
Is that what you want to know, so that we can then drill down on, is there any basis for that coming in?
Right. I need to
that what
know
you mean?
what the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that
Yeah,
he's saying the
okay.
source is Mr. Huey, but there's just so much information that's just
Okay.
like being thrown out
Okay.
with no declarant, no identified declarant.
Sure. Okay. So first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source if it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay.
That's a tiny step forward.
All right.
This really should, because everything is so late. Tough shit. Judge Glanville did wrong. Yeah. As Preacherman 101 says, Judge Glanville had the nerve to disrespect Attorney Steele by saying he was unprepared. But look at the state the judge has them looking like amateurs. Yeah. Judge Glanville's conduct in this trial is beyond misconduct, way past the limits of any stretch of the definition of misconduct. It is appalling. And now look at the state. They have had these jailhouse calls and everything and interviews for years. And now they are going to, I don't think they listened to it. Actually, they were preparing to just play it all because Judge Glanville was on the stand. They haven't actually listened to it.
So what else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good. So I don't have an agenda anymore. My agenda got hijacked. What else can we do that's productive today?
You can call a mistrial.
Anybody have any ideas? Mr. Steele. Okay.
I could get you brief very fast, but I argued this before the recused judge and it was denied. The former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost. And then the Supreme Court of Georgia denied cert.
Okay.
But there's a ruling on it.
Okay.
So if you don't want to rehash it.
I don't even know what you're going to.
Okay. What Mr. Steele does not mean he lost the appeal on a certain decision. What he says is Judge Glanville didn't give him a certificate to bring this decision to the appeals court. And the appeals court said, you need a certificate. He appealed to the Supreme Court. And they said, you need Judge Glanville to give you a certificate. We can't do anything about it. It's not that he lost the actual material he was bringing to them, just the certificate part. So now I assume Mr. Steele is asking, please, Judge Whitaker, give a certificate so we can move, because she clearly says she won't redo. That means the defense should have the right to appeal Judge Glanville's decisions.
Ask about.
The indictment is fatally defective.
Okay.
So I could take a quick count, if you don't mind, right now, and it should apply to,
Okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean, if it is something right offhand, if it, Go ahead.
Okay, well,
Go ahead.
it's a general demur. I was going to do it again at appropriate time, but since you asked.
Is there anything else to do right now? Okay.
So in count 56,
You know what? Let me grab my copy of the indictment. Okay, count 56.
I'll get you the page.
Give me a minute.
It's page,
Okay, got it. Page 90.
okay, so that charges Mr. Williams, I'm just using this as an example.
Oh,
It
okay.
repeats charges Mr. Williams with participation in criminal street gang activity. And it gives a date range. And it says the essential elements need to be there while occupying a position of organizer, supervisor, or other position of management or leader of the criminal street gang. YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault with a deadly weapon, armed robbery, hijacking, and motor vehicle. Sorry, I apologize, Ms. Winfrey.
Street gang is.
Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018 and the 8th day of May 2022 while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm and possession of a weapon by a convicted felon contrary to the law, the state, good order, peace, dignity thereof. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There
Okay.
are 4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge that gives the essential elements. And that would be
This is interesting because this goes all the way back to the grand jury, and if they didn't find the specific elements required to bring this specific charge, then it should be dropped on its face. The Judge Glanville denied it. Attorney Steele asked well, I want to appeal this. Can you please give me a certificate so I can appeal it? And the judge denied that too.
pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56, and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue,
Okay.
but they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it. And that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 US 246 at 252 1952. It's also explained in Elonis, ELONIS versus United States, 575 US 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723
Okay.
at 734. It's a 2015 case.
Okay.
It's in Division 2B.
Yes, Gwenin. Judge Glanville denied the defense the certificate needed to appeal this to his decision to a higher court in order to get it possibly reversed. The Judge Glanville said, you can wait until after trial with that appeal. Because he knows that if convicted, that will be included in the appeals, And Judge Glanville, with that, counted on that even though this particular decision was in error, in a major appeal of the entire case, chances are better for Judge Glanville that it won't be, the appeals won't get through, which is extremely dishonest by Judge Glanville.
And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, the Georgia Supreme Court, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang.
Mhm.
That became an essential element. That changed our jury pattern instruction.
Yeah.
And our grand jury did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks at 24-4-418 kicks in. But I believe that the charges for the gang is not appropriate.
And did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
They didn't take it up.
They didn't take it up.
I
Okay.
didn't get under Dukes, Dukes. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never.
I thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and.
Did not. They said it's not a collateral order. I
Okay.
needed a
All right. So they
certificate.
gave you an opinion on the merits of, is this a collateral order thing you can take up? Okay.
And then they dismissed the appeal. So there's no
Right.
rule of the case.
Okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promise that.
Okay.
in the-
And are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an essential element in count 1,
Okay.
which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury courthouse. Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And
I remember this one. It wasn't on one of my streams, but I watched another stream, which I don't remember at the moment, where this was brought up, that is the difference between the Trump RICO and this RICO, is that this willfully and whatever's, that specific language is in the Trump case, but not in this case. That's really interesting.
that's RICO conspiracy count starts, I think, at page 12, but hold on.
All right. And so you're saying nowhere in, I'll read it. It's pages 1 through 68 of the indictment, but no, I'm sorry, 12 through 68. You're saying nowhere in that 50 something pages does it allege any of this was to further the interest of the gang?
No, I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in that, in
Okay.
count 1,
Okay.
the conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who are here, also the others who are not here, unlawfully conspired to acquire and maintain indirectly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened?
It's extremely interesting because Judge Whitaker is on the short list of the, if a place at the Georgia Supreme Court opens up, she is on the short list. So this argument here is in her wheelhouse. This is something she might want to hear as a Supreme Court judge. Because this is, this is, now we're into the nitty-gritty stuff that almost never gets brought up in court.
What happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is C-O-T-M-A-N, versus State, which is 342 Georgia Appeal, 569, it's in Division 2.
Okay.
The 2017 case, that is a teacher from the APS trial. It was also a RICO conspiracy case. The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is MC-ARTHUR versus Beach, which is B-E-E-C-H. Haven, which is H-A-V-E-N Baptist, B-A-P-T-I-S-T Church of Athens. It's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D, 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit 2 or more predicate acts. There's also Wiley, which is W-Y-L-I-E versus Denton, D-E-N-T-O-N, which is 323 Georgia Appeal, 161, it's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, S-P-A-C-E, comma, Inc. versus Dan Tanners, D-A-N-T-A-N-N-A-S CNN Center, LLC, and that's at 349. Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it.
Mhm.
He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, EUBANKS versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. And I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, Heath. Once the jury's sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that.
Okay.
I mean, intentionally, because jeopardy attached. So.
Sure. Yeah, and if it is already in writing, I'd love to have that. And as I assume this got argued at one point before, if the
Yes.
prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order, and I filed that in a motion that I gave to this honorable court.
Okay.
I'll get the motion, I attached it, but I didn't give you my brief. So the court's permission, and of course the state has it already, but I'll resend it.
Is it filed in the case somewhere or?
Went to the Court of Appeals.
Oh, okay, that brief. Yeah, sure. I'll take it all.
Okay.
And then I'll assume the state filed some sort of a response, maybe not this team right here, but, and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's
No,
worth.
the state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So,
Okay.
and it's a long order,
Yeah.
12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay. Thank you, Your Honor.
Thank you.
I'll get you that brief.
All right. Appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date
Okay.
of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was held on November 20th, 2023.
Okay. Okay. Thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great. Thank you. Appreciate that. All right. Mr. Harvey, you look like you also were maybe going to stand up and come up with something we could do. Oh, and you know what? Hang on. Sorry. If I don't do things when I think about them, sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you?
I think under the rule, we were all joined in.
Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts that they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once they're on the witness stand. So I would like an instruction. I could write this out. I can ask for an
That'd be
instruction.
great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for, like, I mean, I know, like, if you're on the stand and then we take a lunch break or a restroom break or something.
Bruce Harvey, you legend. You legend. You caught that. You caught that. I must admit, we have the same rule here in Sweden. Once a witness starts to testify, say it goes over to the next day, the only person here, at least, he is allowed to talk to is his lawyer. Not the prosecutor, not the defense attorneys, if it is a normal witness. And regarding if the defendant himself or herself is taking the stand, then not even the defense attorney is allowed to talk outside of court records.
That's one thing. Is there anything about, like, overnight that is different?
Only for the defendant.
Okay.
And the defendant's counsel. That was the whole basis of Perry versus Leak.
All right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that, yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
Hazy
close.
memory.
Yeah.
I agree, Heather. I just thought the laws were weird in Georgia this whole time when Glenville said that. Yeah. Everybody in the... It was weird when Glenville said, except the parties. So, yeah.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case, not from within Georgia, but it literally spoke directly to it. So I was at least looking for that, because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's make sure we get it right. So I'll submit whatever you want to submit on that as well.
So Bruce Harvey quoted the United States Supreme Court, and Ms. Love said some other court. Yeah, if they have to go outside of Georgia, the Supreme Court has precedent over random court.
All right. Thank you all. We're going to take a recess right now if there's not anything we can do immediately. And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed? Okay.
A few minutes done. That is essentially a bathroom break. Holy crap. Yeah. Instinctively, Ms. Love is lying. There might be a case that didn't get appealed or went up to the state's Supreme Court. Rule 22 is when once a witness starts to testify, they are prohibited to talk about their testimony with more or less anyone. That's the distinction that Ms. Love tries to say, that we can talk to them. We just can't talk about their testimony. But that kind of includes, remember the plea deal. Yeah, that was a great catch by Bruce Harvey. Great catch. Great catch. While we wait, let's see here. While we wait. Dun, dun, dun. While we wait.
Something, but I don't think there's any way to sit here and try to say, well, maybe there's a reason they seem unprepared. There's just no excuse for it. I don't think there's an excuse.
Cat.
Look at you guys. Yeah, nobody agrees that they are prepared. Just crazy. And then factual lie, good point. I landed here on accident, but good point. I bet Steele has been having chats with Ashley Merchant. Now, we don't want to discredit. Steele's also good. He has a great appeals record. But that Trump line, talking about that RICO, the fatal flaws in that indictment against Trump and his co-defendants in that RICO case, because it wasn't just Trump that had counts, dismissed because the indictment was inherently flawed. But, I'm sure that's something that Ashley Merchant is very familiar with. They could be talking. And I do think Steele made this initial motion for this a long, long time ago. Like, it might have been 2022. I didn't hear the date, but I think it was 2022 already. And then he was trying to argue for it. And then in 2023 is when Love referred to the transcripts where Glanville finally addressed it in court and denied it. So it may have been before all of that stuff started with the Trump RICO. But it's just crazy. Can you imagine if all of this 2 years later and half of this is knocked out because the Supreme Court ends up looking at and agreeing that the counts are flawed from all the way back in the indictment? All of this time passes. And then thank you so much. That's so nice of you. Kimmy Sue, you became a member. Make sure you use your Mario Kart emojis. And then I can relate and living in truth. You guys just both sending a pure $1.99. No comment or anything. That's so nice of you guys. Appreciate you guys. We've been going for 6 hours today. I see Casper in the chat. You guys show Casper some love. And yeah, so correction in here, guys.
No. Steele didn't argue that Trump has a stronger case. Steele argued that the language in the indictment is in the Trump case is different than in this RICO case because they had the language of knowingly participating or whatever's.
Link. Oh, okay. You're stream sniping. You're still on your. Hi. Okay. Everybody say hi to Nick's chat. Okay. And thanks, Aaron. So 6 counts for Trump. Sometimes I'm bad with the recall, but every once in a while I get it right. Yeah, we got some love for Nick over here. We're waving over to Nick's chat because his stream is streaming this stream. And we're also going to be monitoring if we come back on time at 3 p.m. Oh, look at you guys. We're like 2 worlds colliding. Oh, so Max Shard's wife is a lawyer as well. I never really heard her name come up. Got to find out more about her, see what she practices in, get her some spotlight.
You know what, folks? What? Since she's doing the rest of it, I'm just going to send y'all over. So, yeah, say hi to Kat because I need to get to bed. I will do the rest of the trial on my channel tomorrow morning. Okay? Okay? Oh, I have to actually redirect you guys. I actually have to do that. Sorry. Forgot. Studio. Content. Customization. Redirect. Cat, not Williams. Save. There. All right. I'll be sending you all over. I need to get to bed. Thank you all for being here. Thank you all. Recused Judge Campbell became a YouTube member. Oh, that's so funny. Thank you for allowing me to do this. And hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. All right? See you tomorrow, folks. Bye-bye.